Daily list item 1 for motion.
May please.
Yes.
Kindly take up after one matter. So, senior counsel is coming. Yes, sir. This one is coming.
Item 16.
May please, your lordship. Lordship, senior advocate D. Mojumdar is appearing in this case. He's in legs in courtroom number 6, your lordship. He's in legs in courtroom number 6.
I'm sorry. Similar matters are fixed on Milord the 23rd. In fact, Milord, the matter was listed before court number 1. Honorable Chief Justice was of the view that matter should be laid before these dates. So, Milord, I'll only pray, Milord, similar interim order may be passed and it may be fixed on 23rd. The interim order is at page number, Milord, 125. Para 10. It's the order starts at, Milord, page number 122, and the operative portion is at 125, Milord. Para 10. Order.
What's the land acquisition of that airport?
Yes, Milord. Metropolis. In fact, Milord, the issue is covered by a Madras High Court judgment which has been affirmed by the Supreme Court. Effectively, state technically. Last order. Extension, compliance. My lord, this was the order by which the matter was of the Honorable Chief Justice, where my lord matter was tied up to this bench. Is there, my lord? Yes. Oh, that was something. Yeah, last order. Did that.
only allocated in 19 nothing or only other 18 19
আমার লেপে 18
only 18 or only other both
18 কি
allocation number 18 and 19 আছে
My lord, in the present case, my lord, the yes, my lord, that is at the page 122. That was the first order. In fact, there are 4 cases, my lord. First order was passed by this honorable bench at page 122. And this second order also was passed by your lordship. In fact, all the orders are by this honorable bench.
If Lordship may be pleased to one order, Lordship.
My lord. No, my lord. No, my lord, as I lordship informed your lordship, my lord, exactly similar issue Madras High Court has held in the favor of the parties and Supreme Court has affirmed that order. My lord, issue is very simple. By virtue of Article 254(1), the Act of 1964 stood repeal. But by undertaking and my lord amendment of the Central Act, how can a repeal act be revived? Madras High Court has said, my lord, that if you want to revive it, then you go whole off and seek presidential action afresh. And that has been affirmed by the Supreme Court. In fact, my lord, if a lordship recollects that Calcutta Municipal Corporation case, Supreme Court has recognized 7 rights. And one such right is, my lord. Okay. Yes, my lord, just for, I'm just, this submission is towards Honorable Justice Das, my lord. The matter is very simple. After the 2013 Act came into being with effect from 1st of January 2014, all laws on this subject stood repeal. Now, when the state invokes 1964 Act, then without passing an award, they can take possession of the land. Whereas in Calcutta Municipal Corporation case, Honorable Supreme Court has recognized 7 such rights. And one such right is, my lord, even to object an acquisition, apart from other benefits, my lord. Now, because by virtue of Article 254(1), the Act of 1964 stood repealed. Whether that repealed Act can be revived by undertaking an amendment of the Central Act, by which, my lord, Section 105 capital A was inserted in the instant case, which we are laying a challenge. And my lord, kindly see, this state has option of invoking 2 acts, 1964 Act and 2013 Act. How can that be, my lord? In Nagpur Development Authority's case, way back in 70s, Supreme Court had said you can't do that. So recently the law is well settled, my lord. Because the field is covered by a central legislation, the state cannot tinker. Yes, if state comes up with measures which is more beneficial to the people, then it can be invoked. But nothing. So now kindly see, my lord, they are taking possession of the land on the strength of the 64 Act without an award, without paying anything. And they would like to say that we'll pay compensation under 2013 Act. That is, my lord, absolutely not permissible.
Because my lord, all the similar matters are coming up day before,
Day after tomorrow.
Day after tomorrow. So this matter may also be taken day after tomorrow. Lordship may be pleased to issue a short notice. We will satisfy this honorable court that so far as my lord, the competence of my lord legislature is concerned to enact my lord land acquisition laws, it is to be found my lord in the concurrent list. So both the state and the state legislature are duly competent, my lord, to enact laws pertaining to acquisition of land. Now, there are instances in other several states. We will draw the attention of this honorable court, my lord, when the matter is finally taken up for final hearing. Since lordship has already passed, my lord, protected the petitioners in few matters, my lord, they may be protected in the interim, my lord, so far as, my lord, their dispossession is concerned, because they are alleging, my lord, that they may be dispossessed. To that extent, lordship has, my lord, was pleased to protect. So all the matters are coming up, my lord, day after tomorrow.
Here, my lord, LA case is 18 and my lord, village is Azara. In the last case, my lord, it was 18 and 19 and Azara and. So here, my lord, LA case number 18 and village is Azara.
That lordship will precisely find in, my lord, page number 53.
Yes.
Page number 53 of the writ petition. That is, my lord, the requisition order.
Huh.
My lord.
And there, let our proposal go. I'm sitting. Yes, day after tomorrow. Note.
You are.
Facts are more or less covered by the submissions on facts and law is by and large covered by order dated 26/6/2026, passed in WPC 3516 of 2026. Accordingly, in place for the notice and listing the matter on 23/7/2026. Then other matters are also fixed. Next. The learned advocate general has opposed the prayer has submitted that his submissions is also covered by the order dated 26/6/2026, referred above. Either as it be. Order to be listed on 33/1/2026. It is inclined to issue interest return number 123/7/2026.
Order to complete.
The implemented, while that the petitioners shall not be disposed from their hands in the next date of this week. Next, it is made clear that the extension or continuation of the interim order shall not be automatic and only go by default, but shall be subject to further order in the bracket S that may be passed to the next date fixed next list on 23/7/2026.
Deeply applied.
Deeply.
Time being item 16 for motion.
Met with your lordship. As a petitioner before your lordship, was commissioned as an officer in the Air Force in flying pilot fighter stream. And he was posted at the relevant point of time at Operational Conversion Unit OCUA, Kalaikunda, West Bengal.
We'll issue a notice, but in this stage, we can't give an interim order.
My lord, there is a reason, my lord. Well, the Supreme Court says if I do not challenge it at the appropriate time, challenging the two things, my lord. One is the very court of inquiry directed is without jurisdiction. Absolutely clearly, the rule is very clear. The commanding officer under which unit I was there had the authority under the act and the rules to direct court of inquiry. It was not directed him by me. And on the following day, an order of attachment was passed to regularize that, whether that is permissible under the law. That is the question number one. Second is, my lord, at every stage I'll show the order copy of the complaint was not furnished to me. The witnesses' statements were recorded in my absence. I was not given the right to cross-examine the witnesses. And they say that you were given the opportunity to it was read over to me. And rule says I should peruse it. Copy of the complaint should be furnished to me. And the statement of the witnesses were not recorded on oath. This is my second part of the argument, my lord, that the right opportunity to defend myself was not given to me, and in complete violation of the rules. First part is, my lord, he had no jurisdiction. Lordship will give me just 1 minute. I'll show that he had no jurisdiction, and they were passed an order on the subsequent date of attachment in order to validate an invalid order, my lord, whether that is permissible. And it's absolutely clear from the rules, my lord. Lordship will give me just 1 minute. I'll satisfy your lordship.
But the allegations are becoming often, officer.
My lord?
The allegations are which. So there is becoming often officer of.
My lord, at this stage, I'm not entering into the merit of the allegations, my lord. I'm only saying that I want a full opportunity first. And second, the court of inquiry itself has to be directed by a person who is competent, authorized under the law. He is not authorized, my lord.
That is the Air Force Act.
My lord.
Air Force Act.
My lord, I have a copy. I'm furnishing my copy. Copy of the petition as an text.
Section.
My Lordship will kindly take up Rule 154 of the Air Force Rules 1969, which was, my Lord, framed in exercise of power conferred by the Air Force Act.
Officer in command of any unit.
My Lord, it says 154B. First, will kindly see 154 subject 2, my Lord. A court of inquiry may be assembled by the officer in command of any unit or a person, we are not concerned with the second part, in command. Now, Lordship will kindly see what's it there? Air Force Act for a moment. Officer in command has been defined under section page 12 of the rules that I have furnished.
Yes.
Page 12, section 4, subsection Roman 15, my Lord, of the Air Force Act, my Lord.
Just a moment.
My Lord.
Well,
My Lord.
section 12.
No, my section 4, Roman 15.
Commanding.
Roman 15, my Lord, page 12. Commanding officer used in relation to a person subject to this act means the officer for the time being in command of the unit or detachment to which such person belongs or is attached. Now, in our case, what has happened? I was on a temporary duty here in Chabua, but I am under the control of the commanding officer at Kalaikunda, West Bengal. My entire unit had come here along with my commanding officer, because at that time the air runway was not working, so we did not have any work. Our entire unit had come here, so I was on a temporary duty here, so along with the entire unit and the commanding officer. Now, the commanding officer of this unit, Chabua, 14 wing, he had no control. For that, an order of attachment is necessary. Now, the attachment order, when they have realized the mistake, they have passed the order on the subsequent date. Lordship will kindly see page 40, madam. Page 40, madam. Page 13.8 is the order of directing, my lord, assembly of the court of inquiry. That is on 23rd of December. They realized the problem and the absence of jurisdiction. On the following day, on 24th December, they have passed this order, my lord. Attachment of officers. A court of inquiry has been ordered at 14 wing. 14 wing is Chabua, Dibrugarh, my lord. Involving so the petitioner, my lord, Goyat. And then Nikita, she is the complainant. Said officers are prime witnesses in the said court. Now, para 2. With immediate effect, WIE, comma, above mentioned officers are attached to 14 wing. Now, this attachment order in terms of section 4 subsection Roman 15.5 was done on the following day. And they were aware of this absence of jurisdiction. Now, the order of attachment passed on the subsequent date, whether it will validate an order which is absolutely illegal without jurisdiction, he had no competence at all, my lord. And both of us, my lord, the petitioner as well as the complainant, both are under the command of the, my lord, Kalaikunda, West Bengal. OCU A.
No, but you see,
My lord.
let us say any department.
My lord.
For example, let us say PWD.
My lord.
PWD, let us say that this PWD has a wing for this particular courtroom.
My lord.
Now, for some reason, there is no work in court number 4
my lord.
for the tiling for the PWD, so therefore there are some work to be done in court number 3.
Right.
So the officers of PWD are deputed here. Naturally, the head of this PWD court number 3 wing, others if they are coming, they will be under the administrative control of the
My lord,
head of the court number
lordship
3
is
only.
absolutely correct. In the absence of any rules guiding this specific, this situation, this is the correct proposition, my lord. In our case, my lord, rules are absolutely clear. It says, my lord, what is this detachment? Detachment means there is a unit, my lord, a part of the unit. Dictionary meaning of detachment says a part of the unit or a troop. If they are removed from there for a temporary mission, then it becomes a detachment. And here there was no detachment because the entire unit came here. In Dibrugarh, my lord, it's an army station having so many units. In our, from the place where I have come, there is only one unit. Entire unit had come, along with the commanding officer. And the complaint was also made to my commanding officer, her commanding officer. So it was his jurisdiction, he could have done it, or by an attachment when he issues jurisdiction. Here the attachment, they realize that unless there is an attachment order, he has no jurisdiction. So the attachment, otherwise, why should they pass an order of attachment, my lord? Attachment order was passed only to come within the meaning of section 4, subsection Roman 15, my lord. That itself takes away the jurisdiction, my lord. Not only that, my lord, they were so biased, my lord. Entire proceeding, also, copy of the complaint was not furnished to me. I was not given the opportunity to read it. Evidence was recorded in my absence. Now, they subsequently, in a reply to one of my applications, they say, you were present on that day. I said, please preserve the CCTV footage. We have preserved, but they have not done it. Statements were recorded on dictaphone, my lord. Dictaphone was not preserved. Statements were, when the witnesses depose, their statements are allowed to be amended, saying that through mail, you amend it. Cross-examination, I was not allowed. Their statements were recorded, not in my presence. This is the second part. Whole process was done in total violation of the rules, my lord. Whereas, my lord, rules say, and I'll show one judgment of the Supreme Court which says that you have to raise at the appropriate time if the opportunity was not given. Mandatory provisions of the, my lord, army rules, Air Force rules, says that opportunity has to be given, copy of the complaint, etc. Interesting. Page
360.
Where is it that you did, when you're not given the complaint?
My lordship will kindly peruse 2-3 paragraphs of my petition where what I have alleged. Page 16, my lord, para 20. And page 16, para 20. The petitioner states that a copy of the complaint was not provided and the petitioner was never present on 23rd December 2025 when the court of inquiry started. As such, there is violation of Rule 156 of the Air Force Rules 1969 and violation of policy dated 3/11/2025, presence of named person in an inquiry. I have to be present there. In my absence, they are doing everything. The petitioner was never provided with a copy of the complaint and terms of reference throughout the inquiry. The copy of the complaint dated 23rd December 25 was for the first time provided to the petitioner on 18th February 2026. When a copy of the proceedings of the court of inquiry was provided to the petitioner before the commencement of summary of evidence. As such, the petitioner never saw the complainant complaint dated so and so till 18 February 26. It is pertinent to mention hearing that conduct court of inquiry which allegedly started on 23rd December as per the authorities concluded on 30th of January 2026. That the petitioner states that in redressal of grievance application dated 11/3/26 addressed to his commanding officers OCUA had specifically addressed the issue of not receiving the copy of the complaint in para 18.1. I was never given a copy of the complaint in so purportedly submitted by witness number 1. The complaint in the case of so. However, in reply dated 2/6/2026, titled as the order of application on application dated so by para 3.2, the respondent authority stated that the complaint dated so was part of the terms of reference of the court of inquiry and was read out by the court of inquiry to you on so. Law says I have to be furnished with a copy of the complaint and I should peruse it. Word peruse is there. Now they say it was read out to you. Now read out to you on a day when I'm not there. I said you preserve the CCTV footage to show that I was present. I was not present there. Now second paragraph, my lord. The petitioner states that fact that the respondents have stated that the complaint was read out is also a violation of the laws because as per the policy dated so, policy on presence of the named person para 6 states that in any such proceeding where the named person has been included ab initio, such a person should also be allowed the opportunity to peruse the complaint if any. This substantiates the fact that the petitioner was never given a copy of the complaint for his perusal, which is in violation of Rule 156(2). Then para 23, my lord. The petitioner further states that the respondent authorities would have never read out the complaint on 23rd December 2025, as on that day, petitioner was never called for the court of inquiry proceedings, and this fact can be substantiated by CCTV footage of that day, 23rd December 25, covering the entrance of the court of inquiry. The petitioner, in fact, submitted an application on 20th of February 2026 to the concerned authorities to preserve the CCTV footages concerning that day. Thereafter, a reply dated so was given there, whereby the respondent authorities have stated that the same is preserved for perusal. That the petitioner states that terms of reference were never provided to the petitioner and the same was never read out or provided to the petitioner. As such, the petitioner was never aware of the scope of inquiry that was going to take place against him. This is in complete violation of the policy dated 3/11/2025, presence of named person in a court of inquiry, which states that the terms of reference are read out by the court of inquiry. It is further stated that no such annotation of reading of terms of reference has been made in the report of the court of inquiry. Now, second paragraph 25, I have stated that their statements, rule says, should be recorded on oath. Oath was not administered. Then I have given all these, paragraph 26, also will kindly see that the petition states that in utter disregard to the laws, the evidence was recorded even before the administration of oath to the witnesses. This fact can be substantiated by the cross-examination of Group Captain S. So, who was witness number 10 in the court of inquiry and witness number 9 in summary of evidence. For instance, question number 381 at page 78 of the summary of evidence. Is it correct to state that before the VC presiding officer of the court of inquiry was already taken your statement through your mail? Answer, yes. Statement has to be recorded in my presence. I should be given the opportunity to cross-examine him, and his statement was recorded by air directly to him. And subsequently, I'll show they were allowed to amend it because situation demands in order to fix. There should be some amendment, there should be some improvement. That was also allowed. The entire inquiry was vitiated, not only because of violation of the rules, but because of the violation of the principles of natural justice. No opportunity whatsoever what the email was given to me. Now, in such a case, now the court martial has been directed. Actual trial will start now. If I do not raise the objection, almost Supreme Court says, a similar perimeter provision is there in the army rules also. I am for the airport rules. Lordship will kindly have a look at this particular paragraph of this 2022 SSC 714.
But where is your complaint before the authorities that you were not given that opportunity of providing the complaint or the result of that complaint?
Page 104.
104.
First two.
That was the first complaint. The reply is now page 107. Detailed presentation. Yeah.
And we have a copy of that regulation of proceedings. We have a copy of that.
Proceedings, man.
Regulation for the proceedings.
Yes, yes, man. So 156. Lordship will kindly see Rule 156 first minor. The mandatory provisions which one 56 of the rules minor.
156.
56 minor.
The rules.
Minor.
Yes.
And it says, my lord, the court shall be guided by the written instructions of the authority which assembled the court. The instruction shall be full and specific and shall state the general character of the information required. They shall also state whether a report is required or not. Save in the case of a prisoner of war who is still absent. Whenever any inquiry affects the character or service of reputation of a person subject to the act, full opportunity must be afforded to such person of being present throughout the inquiry and of making any statement and not giving any evidence he may wish to make or give, and of cross-examining and witness whose evidence, in his opinion, affects his character or service reputation, and producing any witnesses in defense of his character or service reputation. When a court of inquiry is held on prisoners of war, this is not required. So this is the mandate, my lord. Now, there is a regulation. I have handed over a copy of the regulation also, my lord. This regulation says right in the beginning, you have to give a terms of reference.
Yeah.
The terms of reference also was also not furnished to me, my lord. If your lordship has a copy of this regulation, my lord.
Yes.
Regulation, lordship, regulation 9. And a fourth page, lordship will find court of inquiry, terms of reference. Yeah. This is regulation 784, terms of reference. My lord, fourth page, lordship, I find that court of inquiry 784, terms of reference. In order that a court of inquiry can properly inquire into any matter, it is essential that assembling authority provides the court with suitable and precise terms of reference, pointing out the exact aspect of the case on which the court's findings and recommendations, if any, are required. The terms of reference should also clearly state if the evidence is required to be taken on oath. Then, my lord, thereafter, lordship will kindly see the regulation 788, Court of Inquiry, Proceedings of Court of Inquiry and Recording of Evidence. 788, man. My.
Once. What else can be the terms of reference?
I'm just saying that how the proceedings have been conducted. Terms of reference is only one of the things. Otherwise, absolutely, well, I have to defend myself. I have to cross-examine. These are the basic things. Lordship is aware of that judgment, which says right of cross-examination is a fundamental right. That fundamental right also I was not given, my lord. I was denied.
Yes. 788.
788. It says, see, my lord, the evidence of witnesses in examination and cross-examination should be recorded in first-person narrative form and not in the form of question and answers unless the court thinks fit to record any particular question or answer as such. Now, my lord, 789 says about oath, my lord. When an inquiry is held on prisoners of war and in any case, other case in which assembling authority so directs, the evidence shall be taken on oath or affirmation. The court shall administer the same oath affirmation to witnesses as if it were a court martial. Now, in our case, through mail, he takes, then he says you amend it. So there is a complete violation, my lord.
Where is that? Let it show us the
My lord.
record.
My lord. আমি তো continue. ठीक है.
You came from elsewhere. What is your unit there? Unit number?
That is called OCUA.
OPUA.
OCU, my lord. It is called, my lord,
Okay. Whatever be OCUA.
yes.
And then you come here and you are attached to 14th wing.
14 wing, Air Force, Chabua, Assam, on temporary duty. And that is why that subsequent order of attachment on 24th. Otherwise, what is the use and need of this subsequent order of attachment on 24th, my lord? It is only to bring it within the purview of section 4, clause Roman 15, my lord, attachment.
No, because you see,
My lord.
your stand, please come to page 104.
104, yes, my lord.
This is your letter
my
way back in 12th January 2026.
My lord, my lord.
Paragraph 2.
My lord.
I came to 14th wing as a part of unit detachment on 15th December 2025. Currently,
Yeah.
I'm attached to
Yeah.
14th wing. That means you are aware that where you are attached.
No, attachment, my lord.
It was only a basic link. That formal order was not there.
No, my lord.
You are aware that you were attached.
My lord, two things, factual, here are two things. If it is a detachment, since the entire unit came, my lord, what happens, my lord? Detachment means a part of the troop comes for a mission. And the main part remains there. In our case, the entire unit came along with my commanding officer. So long as the detachment continues, it is not a detachment, in fact, it is the whole unit has come here. So I have come along with my commanding officer. So he continues to remain my commanding officer who was there. So far as attachment is concerned, so as to give jurisdiction to the commanding officer of that station, my lord, that came on 24th. And that is why the order, otherwise, why do you pass an order of attachment then? The purpose is to bring it within the purview of Roman 15, my lord, section 4. And that being the position, my lord, entire proceeding, my lordship is aware, when the initiation is bad in law and honest, all subsequent proceedings
So
will
you show from the complaint that this has happened to you, in fact.
Yes,
You are
ma'am.
reported.
Yes, ma'am.
Next one, I'll be under 18 days.
So far as this attachment is concerned, there is an admitted fact. I have shown the order. 23rd, the Court of Inquiry was directed, and 24th is the order attachment. So Page 115, Dr. may kindly stay with for a moment. What is this? This 11th February, page 107 is the complaint, second. I'm sorry, triple one. Triple one. It starts from triple one. Lordship will straightway go to page 115 at the bottom, my lord. Details of grievances. Page 115, my lord.
Page 1, this is your complaint.
My lord. Of 11th March, of 11th March 2026.
This is dated
11th March 2026, my lord, page 111.
yes 115 you want us
115 at the bottom, my lord. Details of grievances. Violation of Rule 154 of the Air Force Rules 1969 read with provisions of para 782 and 783A of Regulation of the Air Force. The Court of Enquiry was purportedly ordered by AOC 14 Wing Air Force on 23rd of December 2025. Such assembly of Court of Enquiry by so-and-so in matters involving the applicant and flying officer so-and-so was improper, illegal, and without authority of law. Such a Court of Enquiry was assembled in violation of Rule 154 read with so-and-so. The regulation for the Air Force so-and-so was an independent unit with a commanding officer of the rank of group captain duly posted and appointed by the headquarter AOC 14 Wing, was not the commanding officer of any of the two officers allegedly involved in this case. And I want to petitioner tried to explain the provisions of section 4, Roman 15, then Rule 154. And the complaint was also submitted, as I submitted earlier, my lord, to my commanding officer, because he continued to be the commanding officer at that time. And in para 15 at page 116, I say that it is void ab initio. Then about the subsequent proceedings, my lord, from page 117 onwards, I have stated violation of Rule 156. Procedural part, my lord. Procedural safeguards provisions were not at all complied, my lord, that I have stated from paragraph, second paragraph at page 117. Violation of Rule 156 of the Air Force Rules 1969, read with provisions of para 790A, B, and C of the regulations for the Air Force. Violation of Rule 156(2) of Air Force Rules. The Court of Enquiry proceeded and recorded its proceedings in an illegal, arbitrary, and perverse manner from the very beginning. The Court of Enquiry committed grave violation of my procedural safeguard rights provided by Rule 156(2) of the Air Force Rule 1916, which reads as follows. Then page 118, my lord, para 18 onwards, I have given the specific facts. I was never given a copy of the complaint dated 23/12/2025, purportedly submitted by witness number 1. Then 18.2, I was never asked to give para-wise reply to the allegations contained in the complaint. And the first requirement in a proceeding of this nature is to give me an opportunity to refute the allegations and place on record what is my explanation about that. You say that you have perused. And my lord, this my lord representation or my lord appeal or application is a application under section 27 of the Air Force Act. Now 27 says 27 of the Act says, it's very important. That also they are denying me now.
If a complaint is made, they would respond to it.
My lord. My lord.
Complaint of this nature,
My lord.
the Air Force would normally respond to it.
Yes. It is a response.
In your case, they have replied.
No, my lord.
First,
First I reply.
they have said this is not security. Important, so they tell you the status from security to non-security.
First step. My lord, they say it's not a statutory one. I'm just pointing out my.
No, 27 days, it must receive redress.
Yes.
Otherwise, he would complain to the central government.
Yes. He says, 27 says, any officer who deems himself wronged by his commanding officer or any superior officer and who on due application made to his commanding officer does not receive the redress to which he considers himself entitled may complain to the central government in such matter as may from time to time be specified by the proper authority. It is responsible. Page. Well, page 47 will be relevant in this regard.
47.
47. Reply. Well, this they have replied. I'm sorry, madam. This they have replied on 2nd of June.
They do it.
Page 47. Well, page 52 at the last but one paragraph. There are mentioned as 3.12. They say, even though the application submitted by you is titled as a ROG, examination of your submissions and the evidence on record would reveal that no service wrong has been caused to you. Accordingly, your application merits consideration as non-statutory and is to be processed in terms of AFO 15 and 22. AFO money. AFO.
Change the status. That person, however, indicated that you have not replied into the.
And thereafter, I have again written, they say it's non-statutory, then I have written again at page 132 on 27 June, which has not been replied to.
32
And 15 immediate. 130. I'm at 27. Yeah, now if we do the ultimately if we have to 27. I think it's the second will get a reply, which we will get to. The first will about.
Where is the, where is the recording of deposition?
Deposition. Next question. Depositions. Page 81 of the mechanics. I'll not argue much about the defense he has against the allegations made. Just one question, my lordship, if your lordship peruses, page 82, question number 12. 82, question number 12, and answer, her answer to that one.
And you said that you were allowed, the witnesses were allowed to amend their statement. Where is
Yes.
that?
My lord, my first statement, lordship, may kindly see page 22 of my petition, paragraph 31. I have specifically said, page, lordship, see the nature of allegations I made. From there, itself will be clear. Page 22, para 31, madam.
No, but the document, where is that?
No, lordship, may just have a look at this first and then I'll. Page 22, para 31. The lordship has got, madam. That the
Yes.
petition states that respondent number 6 and 7, presiding officer and member of court of inquiry, has deliberately falsified the following information. As per court of inquiry proceedings, page 17 to 33, it is mentioned therein that court of inquiry team asked 187 questions to complainant, that is witness number 1, so and so, on 26 December 2025, based on the statement given by her before the court of inquiry. However, in reality, the complainant was mailed the unverified copy of her statement on her service mail 39514 at personal@if.in and was asked to amend her statement by respondent number 7 on 26 December 2025 at around 1510 hours. And then I have further stated, she does it and it is recorded on 26 when there was no court of inquiry date. So this is how the whole inquiry proceeded, my lord. My submission before lordship will be, my lord, let them come up with a response to firstly, my lord, the jurisdictional issue. If that order of direction of court of inquiry is bad in law, my lord, the entire proceeding will go. Can they justify this, my lord? And second part is about the violation of the procedural safeguards. At each and every stage, they have done it. And my lord, I just wanted to point out one decision of the Supreme Court where when there's a very material provision in the army rules also, rule 180. And there the Supreme Court says you have to raise the objection at the appropriate time. Subsequently, if you raise when the court martial ends, your objection will not be entertained.
Lordship, just 1 hour back, I have received the petition, so at present I am without any instruction regarding facts. Also, I could not go properly through the petition also, Lordship. So, but Lordship, they could have approached at an earlier stage, Lordship, because that 2nd of June, that was replied, Lordship, and throughout they were participated, and now when this 28 July is fixed for general court martial, they had approached this Honorable Court. So for other lordship, I have to obtain instruction. I am not aware of the facts, what is the correctly stated or not, and proceedings, I have to obtain instruction, Lordship. So they could have approached earlier if they have any grievances.
My first redressal of grievance application, they say it is non-statutory. Then subsequently, when I file proper another one, then they do not reply to that. So that also remains pending, and I have to face the court martial now. First one, which I pointed out, by 2nd June, they say it is non-statutory ultimately. Then I filed another one, which let's just have a look, and that they have not responded till now. Page 111, madam. Page 132, I have given again. 130, page 130. And an addendum at page 132. Now they cannot say it is non-statutory and they have not responded to you. Page 130, 15 June 2026. Second. First one was of 2nd June by this order of 11th March 2026. By order of 2nd June 26, they say it's non-statutory. Then when I filed this application at page 130 with an addendum at page 132, that is yet to be responded to. Then where do I go, man? Manage.
2nd June, that he
2nd
received
June.
on 12th.
2nd June, which you lot will find.
Page 48, probably. Page
No, 47 is 2nd June.
47 is the, yes, 47.
47.
Second June. Page 47 is 2nd June. So here other grievances replied, Lordship, that paragraph 4, page 52. Lordship, the other grievances that were replied through this reply dated 2nd June, Lordship, that paragraph 3, paragraph 3, paragraph 4 also there, Lordship, that the proceedings, that according to law, as per Air Force law, and all the ample opportunities were given. Those were replied. And and regarding the detachment also, it is replied at paragraph 3, page 49, 3.1, that the complaint dated 23rd December 25 was processed by OCUA and was forwarded with remarks to the AOC 14 wing, considering that OCUA was operating its detachment from 14 wing at the time of the incident. The AOC 14 wing was empowered to order the subject COI to investigate the alleged incident that happened at 14 wing. That the complaint dated so-and-so was part of the terms of reference of the COI and was read out by the COI to you on its assembly on 23rd, 25, and annotation to this effect has been made at page 12 of the COI proceeding, which has been duly signed by you. Considering that a COI was ordered to investigate the said complaint, there was no requirement to seek parawise comments on the said complaint from you. It is also pertinent that in accordance with the Air Headquarter policy on presence of named person of the COI, you were present before the COI from the very beginning, even before examination of complainant, who deposed in your presence. Further, she was extensively questioned by the COI in your presence after making the said statement on 26 December 25. Your contention that you were not allowed to cross-examine the complainant and other witnesses until 15 January 26 is false. On 2nd January 26, during application of para so-and-so, we were informed of the likely counts of blameworthiness. All the evidence recorded till then was read over to you, and you were provided all the right and this is threat, including the opportunity to cross-examine the complainant. But you choose to exercise your rights subsequently while choosing to be present in the ensuing proceeding. Annotation to this effect has been made at pages 66 of the COI proceeding, that the provision of para 790 A, B, and C registers were applied on you, and regulations were applied on you and as well as on the complainant on 2nd January 26 on the count which the court felt appropriate at that stage based on the evidence adduced till date. Further, based on the evidence adduced during the further course of proceeding, provision of so-and-so regulations were invoked on you for the second time on 15 January 26, wherein you were informed about the fresh count on which you were likely to be blamed. The evidence recorded till then was read over to you, and you were once again reminded of all your rights. It is pertinent that you availed the said rights and had thereafter cross-examined the witness number 1, witness number 5, witness number 6, witness number 8, witness number 9, and witness number 10, and witness number 11 as a witness in your defense. That the sketch of the site of incident was submitted so and so. Those were their lordship. And page 51, 3.7, that the perusal of the proceeding revealed that the witnesses deposed before the COI in your presence and were questioned by the COI and were also extensively cross-examined by you. Accordingly, your allegation of the COI having taken pre-written statement of the witnesses on record appears to be an afterthought. That the allegation counts against you did not mandate collection of medical or forensic evidence or seizure of clothes, shoes, bedding, etc. Since no such material was seized, the requirement of seizure memo, videography, etc. did not exist. Incident dated 20th December 25 was verbally reported to the authorities on 22nd December. Hence, alcohol test at such belated stage was of no relevance. You raise allegation against the conduct of proceeding of the COI while the COI is still in progress. The application dated 12 January 26 submitted to OCUA through Air Force net mail was processed at 5 wing as OCUA had moved from 14 wing to 5 wing by then. AOC 5 wing had forwarded the same to headquarter EAC. After the receipt of the completed proceeding, your contentions were duly considered by the competent authority and the said application was duly disposed of by details speaking order dated 11 February 26. Your contention that the COI proceeding were vitiated in wake of various court judgment has been examined, and it is brought out that you were provided with all opportunities to defend yourself and you had been present before the COI right from the very beginning in terms of the latest policy issued on the presence of named person. Hence, the essence of the said judgment, that is to provide adequate opportunity to the delinquent individual, has been duly implemented in both letter and spirit. Notwithstanding, it is pertinent to note that the facts and circumstances of incident case is altogether different from those of the quoted cases. Your contention that the officer recording SOE allowed all the PWs to read their statement from pre-written statement is false. It is brought out that the recording officer of SOE was detailed by the AOC and that the SOE was duly recorded in terms of the extent provision. Further, your contention about the officer recording SOE allowing the PWs to call each other on phone or to consult each other during proceeding of the SOE is unsubstantiated. Further, you were given adequate time to prepare your defense and put forth the question then you desire to ask as part of cross-examination, which is also evident from a perusal of the SOE proceeding. Even though the application submitted by you is titled as EROG, examination of your submission and the evidence on record would reveal that no service wrong has been caused to you. Accordingly, your application merits consideration as non-statutory and it is to be processed in terms of Air Force Order 15 of 22. And whereas the CAS having duly considered your application dated 11/26 is of the opinion that the COI proceeding and subsequent disciplinary proceeding initiated against you were conducted as per Air Force law and you were afforded ample opportunity to vindicate your stance. Further, that your contention about irregularities in conduct of the COI and subsequent disciplinary proceeding are without any cogent evidence. So these were the reply of the authorities.
Madam, there is a clear admission that first point they haven't been able to note. Let me just have a look at page 49, one small paragraph. Page 49. In their reply of 2nd June, they have dealt with the question I have raised about the lack of jurisdiction of the commanding officer who initiated the court of inquiry. Page 147, let me kindly see first. It says, may I read it slowly, madam? Complaint dated so-and-so was processed by the CO OCUA. It's my commanding officer, madam, and was forwarded with remarks to the AOC 14 wing. Considering that OCUA was operating its detachment from 14 wing at the time of incident, the AOC 14 wing was empowered to order the subject. I have raised the question, my lord, specifically relying on and with specific reference to Rule 154 and the definition in the Air Force Act, but that has not been dealt with because they cannot justify it. My lord. My lord. My lord. Yes. 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 My lord, 107. My lord. 2.1, my lord. This is 3.
It refers to the incident was brought to the notice of CO on 27 about so-and-so.
Yes.
And thereafter, in your premises and so-and-so, and then 23. And therefore, primarily CO was ordered on 29 after the order of so-and-so. Therefore, this complaint made over to your commanding officer
Yes.
was sent to 14 wing.
Lordship is referring to 3.1 at page 108, my lord.
108.
Yes. It says the incident leading to so-and-so was brought to the notice of the CO OCUA on 22nd December around so-and-so, was undergoing syllabus sorties, which was time-bound and was left with one sortie towards completion of our syllabus. Your presence in the unit premises could have had an adverse effect on safe conduct of trainees sortie, which was already planned on 23rd December. Hence, you were asked to lay off from instructional duties from 23rd December 25 onwards, keeping aerospace safety in mind. This considered decision was taken by the CEO himself. The sortie was completed in first detail on so-and-so. Flying officer so-and-so was present in the unit on so-and-so towards completion of our post-sortie formalities. Moreover, unit was on a detachment for a high tempo, time-bound task which was successfully completed. You were thereafter asked to report to COO section 14 wing from so-and-so from 24th, Lord, kindly notice the date, my lord, from 24th December onwards for further proceedings. So they have not been able to justify that 23rd, the CEO at Tabua Dibrugarh had the jurisdiction because he was the commanding officer. They could not justify despite their sincere effort. And I have raised this objection, not merely saying that you have no jurisdiction, with specific reference to Rule 154 and its definition in the Act itself, an Air Force Act. That they have not touched these two provisions, apart from their normal statement that, see, I am there, you are there, I have considered, he has considered. Or when the initiation itself is without jurisdiction, whether subsequent proceedings can be allowed to proceed further. And that judgment, I was may I just one paragraph from the judgment, madam. Joint court martial order होई किसी को ना? It's a 2022 SSC 714, madam, Union of India versus so and so. Paragraph, my lord, 9 at page 719, my lord. It says about Rule 180 of the Army Rules. This court had occasion to consider the scope of Rule 180, and it is necessary to take note of the judgments of this court in which Rule 180 was discussed. The orders by which General Court Martial was convened were challenged by petitions filed under so and so. One of the contentions on behalf of the petitioners therein was that it was obligatory upon the authorities to appoint a court of inquiry whenever an inquiry affects the character or military reputation of the person subject to the act, and in such an inquiry, full opportunity must be afforded to such person of being present throughout the inquiry and making any statement or giving any evidence that he wishes to make, and of cross-examining any witnesses. Interpreting Rule 180, this court held that it cannot be construed to mean that whenever or wherever any inquiry in respect of any person who is subject to the act is concluded and his character, military reputation is likely to be affected, setting up of a court of inquiry is a sine qua non. That's this Rule 180 is perimeter with the present rule I have referred to, Rule 156. Now, paragraph 13 at page 721 of Mechanism. This is the paragraph on which I am placing the reliance man. Para 13. Though there is non-compliance with Rule 180 of the Army Rules, in this case, as the respondent was not present during the recording of the statements of witnesses, it is clear from the record that the respondent did not raise this ground either at the stage of framing of the charge, recording of summary of evidence, or during the court-martial proceedings. After a final order was passed by the court-martial on the basis of a full-fledged trial, it is not open to the respondent to raise the ground of non-compliance with Rule 180 during the court of inquiry proceedings. That is why I have raised, but they are not responding to. Lastly, when I filed the application, initially when they say non-security, they keep quiet. I have raised it at the appropriate time, and Lord will kindly consider.
Mr. D. Mosmidar, Learned Senior Counsel, assisted by Mr.
G.R. Datta.
G.R. Datta, the Learned Counsel for the petitioner. Also heard Ms. B. Sharma and HCGC, along with Mr. B. Chakravarti and HCGC for the respondents.
For 1, 2, 3, and 4. Others are by name.
Oh. One. By filing this petition under Article 226 of the Constitution of India, the petitioner who is a quadrant leader and is facing a court of inquiry. As you said, 160. The court of inquiry, charge sheet, charge trial, summary of evidence, and the order convening the general court martial with respect of the petitioner. Next. Is projected in this petition that the court of inquiry was conducted in violation of the principles of natural justice, as the petitioner was not furnished with the copy of complaint or the terms of reference. But it is also projected that the petitioner was not given an opportunity to be present when the evidence was being recorded. Moreover, it is further projected that the witness number 1 was mailed the draft reply with enabling the complainant to amend the statement. And such statement was accepted by the court of inquiry on a date on which the court of inquiry was not convened. Full stop. Next. The learned senior counsel for the petitioner submitted. Complaint ventilating his grievances was submitted on 11/3/2026. And dissatisfied with the reply dated 2/6/2026, the petitioner had submitted a request letter dated 15/6/2026 for forwarding the capital R whole G application to the central government. As well as an addendum dated 27/6/2026. It is submitted that in the event, in view of the law laid down by the Supreme Court of India in the case of Union of India and others, as is, just take this EX numbers for this. comma, within bracket 2020, bracket close 2 SCC 714, comma, unless an objection is raised, comma, subsequent to the completion of the inquiry, comma, no objection could be subsequently raised. And in this regard, it is submitted that the preliminary objection which was raised by the petitioner is that he was a member of the unit which was referred to as OCU dash capital A. And the entire unit along with the commanding officer were transferred to a location which was covered by 1414 wing WG, capital W, small g. And therefore, as the petitioner was under the commanding officer of his own unit, the Court of Inquiry ordered on 23/12/2025 was without jurisdiction. Next part. First part, I will say, so it's been done. Okay, and then insert another packet. This will come later. You should notice returnable on how much time?
Before 28th, or
It is
yes,
week after. You'll get it by the
I can try it by 27th.
returnable on 27/7/2026.
If I have to file an affidavit lordship, in that case, I need more time. If only for instruction, then it is. Otherwise,
This nature instructions, they will not do.
then I need at least 4 weeks time lordship, because I have to send it for vetting and first week of September will do lordship.
I think it's the last week of August, 28th August.
Lordship.
28/8/2026. Requisite extra copies of the resolution served on the CGC in course of the day, along with a soft copy thereof, which they never have to pay this. So, the soft copy of the
Yes, it's there.
petitioner shall take steps. Right. 22/7/2026 for service of notice on the respondent number
5 to 8.
5 to 8 by Speed Post PDD. The learned instructing counsel for the petitioner is at liberty to collect the post district number and to submit to track the vote prior to the district of the state. The learned senior counsel for the petitioner's for interim delay. The convening of the court martial,
General court martial. General court martial.
the general court martial. Right. Convening order dated 10/7/2026, as it is scheduled to assemble on 28/7/2026. The said there is proposed by the London CGC on the ground that the complaint dated 11/3/2026 has been duly responded to on 2/6/2026. By which the respondents have projected that there was no merit in the objection raised by the petitioner. Next part. In this case, there is like that. That one. Next one. Accordingly, the court is of the opinion that the issue raised by the petitioner requires to be examined, and therefore the general court martial is convened whatsoever prejudice. Accordingly, where is this order of
Last page. Last page.
convening order? It is 7/7/2026. Issued on 10/7/2026 by the Air Marshal, Air Officer Commanding -in-chief, Eastern Air Command, Indian Air Force at Shillong. By which the General Court Martial convened for the, in respect of the petitioner on 28/7/2026 at 10:00 hour. Is hereby state. Next paragraph. This order has been passed without adequate instructions to the Lanet CGC, respondents are at liberty to move this court for modification of the order. Next, the petitioner shall produce a certified copy of the order for the competent authority. Make this order operative against the respondents. List on 28/8/2026.
Deploy.
Obliged.
Take a short break and come. Your designation, the general is after. And here, the general is before.
That changes the whole scenario.
for admission, supply item 17.
Allowed in this case, the petitioner was declared as foreigner by order dated 31/12/2021. No, sorry, my lord. Page 51. But it was expired order. I am not receiving any notice. Then after that, my lord, SP, Laws and Affairs, is stating that the declared foreigners were living in Assam without any valid passport. A case has been registered. Subsequently, the case is PRC case has been registered and summon was issued. We are also not receiving any summon. And thereafter, my lord, on the extent of warrant of arrest, the petitioner was arrested on 2/11/2025 in the PRC case, my lord. That case arising out of the judgment passed by the Honorable Tribunal, page 51, my lord. Page 51.
Criminal case.
Criminal case. Page 15 is the opinion.
One fact.
Notations have hang in a shop. Yes, yes. 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 Yes, it is another proceeding. I appeared in that case and filed written statement. Then that case also, my lord, after some time I could not appear for cross examination. Ultimately, the case has been bundled for long periods for appellate purpose. Then thereafter, after long time, 2022, it is reopened. Notice has been issued, but the notice not served to me, notice served to my own sister-in-law. I am living seven places, my lord. She has not handed over the notice to me. That order has been also declared me as foreigners as expired order, my lord. Expired order. If that order, page 83, Los Localities, page 83. Yes. No, no, in this case I am not appeared. Page 80 I appeared. In that case I appeared, filed written statement, but I could not appear for some time for cross examination me. And subsequently, in Los Localities, page 83 of judgment. Opinion. The prosecutor has submitted her evidence on evidence also, along with some original copy of documents. Since the matter was fixed for cross examination of the prosecutor, but the prosecutor is taking various dates for cross examination of the prosecutor. Thereafter, the reference was bundled for appellate tribunal for various months, and it was bundled during the tenure of my learned predecessor. The case record is again put up on so and fixing the same for necessary order. By the order dated 14/12/2022, issued the notice to the proceeding on so. The notice was duly served, but the proceeding did not appear before the Honorable Tribunal. Hence, the matter was fixed for necessary order. But since 18/5/2023, the proceeding has not appeared and remained absent without any steps. I, so, the learned resident GP represents the reference authority and fixed on 19/10/2023 for hearing. So, accordingly, my expert order has been I have been declared as foreigners. In against that order, also I filed one writ petition, that is 2/1/25. In that case, I also annexed the copy of the notice, service of notice matter. Mazda Khatun. In that case, one Mazda Khatun has been received notice of Nolonga Paratuli. She is my sister-in-law. My lord. It is same, my lord. I am living in my husband's house. She is my parents' house. It is same, my lord. It is same, hopefully. One Mazida Khatun. In another case, another death copy of the order notice. Mazda Khatun, wife of Saman Ali, Paratuli. My lord. Mazda Khatun is living in my father's house. He is my sister-in-law. I am living in different place. So she has not handed over the notice to me. Yeah. And this is difference. I'm reading this. I go to আমার উদ্দেশ্য কোন খাত
Down, yes, lordship,
মাঝেটা খাত
13.
It's 25. That's why I am leaving my husband's house. Yes. But she is not handed over, she is not informed. Hello. Mas da cruz não é para não poder colocar. Notice to my guy, notice. What do I do actually do? I will notice. Ito na, kung ano kasi ito. Ito. Allora, the record of application number, that record is also available. You will also see the notice.
Page 19.
I will take it from you. This is
No, not one.
page 80 to stop.
I'm up to 89. Yes,
It's the oil. It will wait.
it is related to the payment. You put up a declare, double declare for the
It was kind of a one.
double for
What circumstances the second reference came to be made?
My second another reference case has been made by me. In another reference, it is another case, my lord.
When the second reference was made, the first reference was also pending.
Also, my lord, I am not received any notice in that case, my lord.
That order, final order had not come.
No.
Ex parte order had not come. It was pending.
No, expected order
Had come.
come earlier.
That case, exchange order 2017.
Pursuant to that, this,
I have the receipt, yes.
but in the meantime, the second reference also came.
Also declare I am referred. In that case, I am filed written statement and everything, but first case, my lord, I have not never noticed any notice, my lord. It is also order reflected that they hang the notice in a shop. And person name. Itu tentu. Nolongga. Itu 55. Nolongga. Pak Pudi. Nolongga Pak Pudi bisa. Dan lebih bisa. Yang lain. Pertama botol pertama botol. So Abdul Kadir. Quotation 5 brutal is Mazda Khatun, husband of Abdul Kadir. Notice Abdul Samad. Samanal. It's, in a criminal case, what? Jail. Jail, yes, yes. On the instant of warrant of arrest, she was arrested. Against Sessions, PRC case. Yes, yes, yes. Yes, yes, madam. Then I will be allowed to go on bill then. Yes, yes, yes. My lord, suppose, my lord, if the proceeding expect order is set aside, then ultimately that case also go. Suppose expect order. My lord.
The sister-in-law does not reside with you because as per voter list of 2005, which incidentally you have annexed here also. In this writ petition, you have annexed that. Your sister-in-law's name appears along with you.
But husband is Abdul Kadir. But his notice received Bazda Khatun, wife of Saman Ali. Saman Ali. Voter list name appears Bazda Khatun, wife of Kadir Ali. But here, in notice, it has been reflected as Mazda Khatun, wife of Saman Ali.
The circumstances in which the two proceedings became ex parte
expert.
are different.
Different.
One is that.
One case I appear, subsequent I,
Subsequent.
yeah, and one case I have not received payment and in notice. Okay.
But you never received.
My bad. And if I am not wrong, recently, Honorable Supreme Court decided similar matters. All the expert order, I remain back to
This
the
was the
payment.
next party, you, it was served on you. You filed your written statement.
Yes.
And in the second notice, you did not appear.
Partly
Yes,
stopped appear.
right. But
Abandoned.
in similar case also, Honorable Supreme Court appear, file written statement subsequently not appeared, expiry, those matters also remain back to the terminal below for treasury.
For a different reason. Because it was a non-speaking order, but here the opinion gives that reasoning.
The principal laid down and put that decision at Speaker they.
Saviत्री.
But then, even if it is a case of complete non-appearance, the basic materials have to be discussed. That's one. The third category is that abandoned in between. There also the materials, whatever materials are there, there has to be some discussion. So it was not done. So they were remanded. So that is the principle that we have understood so far. This is of the other read petition, was filed like in.
No, it is, yesterday it was listed, but I look.
If the petitioner is arrested in connection with that PRC case, that is an offense under Passports Act.
Yes.
For that, this writ petition would not be maintained, will not have jurisdiction. It will be
I'll-
moving this court in a regular bail.
Yes, my lord.
And so far as this case is concerned, I think you are protected not to be deported. He shall not be deported. So that extends till the next date. All these ex parte orders, we are taking it up on 3rd. So we'll take up this matter on 3rd.
Everyone and in so far as second petition concerned, that case will come. In the meantime, if you receive a subjective judgment, 0.411, it is clearly stated. And I am reading it.
We'll see that when we hear that matter.
Yes, I am reading it just. In the meantime, other appellant challenge the judgment so and so. WM number so
All
and so.
these cases are listed together.
Yes, sir. The High Court noticed that appellant had appeared before the tribunal. Upon receipt of
Hearing it
notice.
right now. Unless you insist.
Yes, no, my, three, fix. And that case also fixed on three matter. WBC number,
That is also fixed on third.
WBC number 2
That you, whenever it comes, we'll take it up. But for this, we are passing an order right now. Also that presented
2
the government cost of the has submitted that there's some urgency in the matter as the petitioner was arrested on 2/11/2025 in connection with Sessions case number 150/2025 arising out of PRC case number 1532/22 which is, it is still pending. That case is still pending.
Pending.
Which is still pending for adjudication before the Court of Learned Sessions Judge from Kualpara. It appears from the materials available on the record that the said PRC case number 1532/2022 was registered on the basis of an FIR dated 9/5/2019. Registered as RPS case number 09/2019 under section 3 of the Passport Act from 1920 read with section 14 dash capital A within bracket small b of the Foreigners Act of 1946. Stop. Therefore, comma. Next paragraph, therefore, comma. Having heard the learned chronicles for the and bottom methods, comma. As the petitioner was not taken into custody in connection with any opinion rendered by the learned Foreigners Tribunal, but petitioner was arrested for a distinct offense, comma, would be available to the petitioner to move this, move the jurisdictional court and public law, this court in appropriate jurisdiction for bail, for a regular bail. Next one. This bench, this division bench would have jurisdiction to examine the opinion passed by the Foreigners Tribunals and not bail matters arising out of other jurisdictions. By insofar as the present is in respect of the challenge to the opinion dated 31/10/2023 is passed in FT case number page 80. So and so is concerned, comma, by an order dated 18/2/2026, it was provided that the petitioner shall not be deported out of the country without order of the court, which pursuant said order stands extended till further orders. Next paragraph. Matters relating to ex parte opinion are fixed on T8/2026. Next, accordingly, list this matter on T8/2026.
My lord, 226, my lord, this court has also power.
Bail.
Because 226 is there, my lord. Why
I would
power is here, my
appreciate-
lord?
I would definitely appreciate that.
But a lawsuit can do it because 226 is there.
No, we have bigger designs for you. We think that you should appropriately stand in the elections, win the elections, become an MP, go and change the law that bail can be taken up by 226. We would appreciate that. We have very high hopes on you. We want to see you in the.
So, my lord, one observation, there is no bar, so I felt bail application here also.
No, we have already said that you have liberty.
The other reference is the subject of a separate message.
Right.
That's why you can place or copy of this.
So, one observation here also, the WBC number 2125 also may be listed on 3, because since record of both the cases are here.
Yesterday that matter was listed.
Yes,
What
yesterday
was the
listed.
past?
27 item. No other left over.
You make a mention.
But
Make a mention, we let it listed and let it pass orders.
it can be right.
Make a mention to order.
But record of both the cases are here. Of both the
Yes.
cases.
You make a mention tomorrow
Right.
and get it listed and transferred.
Well,
Or we can do it here. Fine, okay, make it. You said list of PA along with WBC
2125 public 2026.
2125 of
2026.
26. Okay,
Hello.
Item 2 for hearing.
Distrust is not there. I think in 5 minutes time, you will not be able to take up any matter. Take a early break. No, Mr. Distrust is normally, he was sitting there.
Item 3 for hearing.
Next one number 61 to next number 2.
Yes.
My Lordship, Azmira Bibi alias Azmira Khatun, he adduced herself after giving written statement, and he has submitted all the necessary documents like voter list of certified copy of voter list of 1961 showing his grandfather, her grandfather, Noimuddin Sheikh. Next one. Annexer 2 page number. Page number 11, Annexer 2. The vernacular is page number 12. Noimuddin Sheikh. And the page number 14 and 13. 13 and 14 is the voter list of 1966. Showing the name of Noimuddin Sheikh, Asok Wasimuddin, grandfather. That's 7%. Annexer 5, total list of 1977. Azmat Ali, the father of the proceeding. Azmat Ali, Aso Noimuddin. Then after every 5 years, have submitted the voter list of showing his father and other relatives. You see the CSV mentioned. Annexer 13 page 33, 34. ECDC has given certificate showing the marriage relation and migration of the proceeding. 34.
school certificate. So, No? Page number 34 has given the VCTC certificate. And moreover, school certificate of the proceeding is page number 30. Alexa, 11. Alexa 11. What question? Father's name is Amdadadi and grandfather's name is Noimuddin. Then all the documents have submitted. And after perusing, the learned tribunal have mentioned he have perused all the documents. The Gauhati, even the Gauhati has given certificate. Hmm? 35, 36, and Annexure 14, 31. All of zero को भी है. हाँ. Okay.
Yes, please continue.
So the documents submitted by the proceeding before the learned tribunal and even as annexed before this honorable court, she is a Indian citizen, showing the all documents that her grandfather's name has appeared in 61, 66. Her father's name has appeared from the 77, thereafter, after 5 years. And she has submitted school certificate. He has passed primary school, class 4. The certificate is submitted. Then VCDC has given documents that she has married with so and so. That is also a kabin nama. The relation has been clearly stated, and the Gabura has also given certificate. He knows her family. So from these documents, the honorable court kindly be pass the order showing her as a Indian citizen. This is the humble submission on behalf of the proceeding.
Yes, Mr. Payne. How many witnesses were examined? How many witnesses were examined?
She was only examined.
Only she was examined.
She, other, who has given certificate are not examined by the tribunal.
Any document of you with your projected father?
Father, the voter list of 1977 voter list, a certified copy. Yes, yes, sir.
1977.
Huh?
77 was not true.
Then his grandfather's name has appeared in 1961 and
Excuse me, one
66,
question.
and his father's name has appeared in 1977.
You're asking me one question. Is there any voter list of the petitioner with her father?
Yes. The father, the VCDC has given certificate that he is the daughter of so and so, so and so. There's the
Yes.
pastor. 33, 34 page number.
Yes. Your Lordship may kindly see the discussions and reason in the opinion matter. The 18 documents were exhibited as per them. Now, after exhibition matter, on perusal of evidence on record, I found that proceeding exhibited voter list of 1997, exhibit 13, 2005, exhibit 14, 2011, exhibit 15, in the name of purported father of Asmat Ali Sheikh. This document is not prior to 25/3/1971. The purported father has filed an affidavit claiming that he is the father of proceeding. Mere filing an affidavit is not, so father did not come and depose matter. We filed an affidavit, admissible evidence. The proceeding exhibited marriage cabin number issued by the Muslim Marriage and so, which affidavit has report that has not been proved. The marriage cabin number is not proved. Asmat Ali Sheikh is proceeding's father, but never deposed the Naimuddin Sheikh is his grandfather. Though the name is in Kabil Nama, the contents of the name of Naimuddin Sheikh is not proved on record in Kabil Nama, and also it is not mentioned that Asmat Ali is the father of the president. Yes. Yes. The Kabil Nama, first of all, Kabil Nama is not proved, so it's a private document, it is not proved. Secondly, he is relying on the BCDC certificate, Malak. Gaubra and BCDC certificate to link himself to the protected father are not proven record. So the petitioner is trying to link himself, Malat, to what Amjad Ali, first of all, then through Amjad Ali, he is trying to link with, Malat is trying to link with Noimuddin Sheikh. This Noimuddin Sheikh is there in 1966 and 70. Now, the first footer list of Malat Amjad Ali is Malat 1997, Exhibit 15. Yes, Amjad Ali Sheikh. Then Exhibit 14, it is of 2005. Then 1997, Exhibit 13. These Malot, don't have the repetition copy, my able to Malot as here. So it's Exhibit 13, Malot. Exhibit 13 to this. 1997. Then next is 2005 Gujarati. Amjad Ali Sheikh. So Amjad Ali was 35 in 1997. That is the first Gujarati of the projected person. So existence, the tribunal is right, Malot, existence of the father of the petitioner in India is after 71. There is no documents of the projected father after before 1971. And his second statement of the petitioner is trying to link herself on the basis of a Kabirnama, Exhibit 16. According to this Kabirnama, my lord, the marriage was solemnized on 29/2002. Kabirnama. And the marriage was solemnized on 29/2002. And it was registered only on 30/10/2014. The marriage was solemnized according to this Kabirnama on 20/09/2002. And according to this this Kabirnama, it was registered but only on 30/11/2014. After 12 years. 14 months. 30/10/2014. After 12 years, my lord. And interestingly, this Kabinlama was not proved by calling the Qazi to the tribunal. The Qazi was not examined. Then the Gaunbura certificate and my lord, the DCDC certificate. These two exhibits, exhibit 17.3 and 18, my lord, exhibit 18. These were not proved by the my lord, writer of this document, my lord. Neither the Gaunbura nor the BCDC came forward to prove this document. So in absence of any my lord, documentary evidence to link the petitioner to Amjad Ali, my lord, if these documents, the BCDC certificate, the Gaunbura certificate, and the my lord, the Tamil is not proved. There is no documentary evidence to link herself to her projected father, Amjad Asmat Ali. And the father, Asmat Ali, to link himself to Naimuddin, the projected grandfather, there is no document at all. In both ways, my lord, the petitioner has failed to establish her link to the my lord, projected Naimuddin Sheikh, who was there in India prior to 1971. So in that position of the case, tribunal has committed no error, my lord, by declaring the petitioner to be foreigner on the basis of those materials. That's all.
We have learned counsel for the petitioner. And so for the respondents. Next. By filing this petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has received the opinion dated 14/9/2016, page 45. Passed by so and so and so and so. That is which he was declared to be a foreigner for 25 to 18 citizens. Please send the records. Next paragraph. On receipt of notice, the petitioner had entered appearance and filed a written statement denying that he was a foreigner or illegal migrant and came to be an indigenous citizen of Assam by birth. claims that her father is Hamzat AMZAT, Hamzat Ali, alias Hamzat Ali Sheikh. And her grandfather is Noimuddin, Noimuddin, alias Noimuddin Sheikh. So he claims to be born and brought up at the village Chataguri, CHAPAGURI, part Roman 2, under Bagri Bari Police Station, BAGRI. District Dhubri, within bracket, now district Kotrajal. Make it good. He claims that the name of her grandfather was enrolled in the voter list of 1961. The name of her grandparents were entered in the voter list of 1966. Their name, her grandfather and the grandparents. They also entered in the legacy, lastly with legacy data, the court specific to them. Claims that her grandfather had died in the year 1970. Accordingly, the name her grandmother, Jamiron, Jamiron, Beva, appeared in the record roll of 1970. The name also appears in the voter details of the legacy records for the state year. The name of her father, Ismail Ali Sheikh, appeared in the electoral roll of 1997. 20, September 2022. Sorry, 2002. He was married with Sahidul Rahman, Shihidul Rahman, a village Poyasti, Poyasta, Salmara, in the district of Delhi, executing a marriage Kabindama. The name was enrolled in the voters list of 1997, village category part 2. The everybody, yes. Now, here's the name. The man. I mean, the petitioner, in order to correct result with the projected problem, has referred to the certificate issued by the Mahimaya VCDC the petitioner has stated that before marriage, her name was Azmira, Azmira, Azmira Hatun, Hatun. After marriage, her name is Azmira Bibi. And accordingly, both are same and non-possessive. In order to support her contention, the petitioner relies on the certificate issued by Gambura of Chatagudi Part 2 and the certificate issued by the chairman of VCDC, Pavan Mahamaya, control. A certificate countersigned by the BDO of Mahamaya block. The other thing, the next order, in support of the stand taken in the written statement, one of the petitioner to examine herself as DW1. And she had filed the evidence on affidavit. By relying on the statements made in the statement. By reiterating the statements made in the written statement, has exhibited the following documents. Take it from page 16 on page 15 to page 41 to page 43. Certain exhibits. VB is voter detail and VL is voter list. We have a list here. Next. The learning counsel for the petitioner, by referring to the various exhibits referred above, has submitted that the petitioner has been able to show in proof that he is the daughter of Asmat Ali, alias Asmat Ali Sheikh. And with the name of her grandmother is Naimuddin Sheikh. Accordingly, provided the exhibited documents were wrongly appreciated by the learned family, which has initiated the opinion. Accordingly, the petitioner prays for setting aside the party opinion. He declared the petitioner as a not a foreigner. Next. Third contract from the learned standing counsel to the water and activities has submitted that the petitioner is trying to connect him to one Asmat Ali, whose name appears in the water list of 1966. They have submitted that to Aspat Ali, the projected father, the petitioner is trying to connect herself to Naimuddin Sheikh, projected grandfather. But subject of the existence of the projected father of the petitioner in the state of Assam is only from voter list of 1997 in bracket exhibit 13. Therefore, the existence of the projected father of the petitioner in the state of Assam is not available. Both on and after the analysis in 1921. Was submitted that the marriage certificate could not have been relied on by the learned tribunal as the marriage disclosed in the Kabinama was held on 29/20/2002. The same is sought to be registered after a gap of 12 years between the and moreover, the author of the Kabinama was not done. So the entry in the Kabinama was made on 30/11/2014. Is for 12 years. So the purported marriage took place on 29/20/2022. Accordingly, the learned beneficiary, the appeal bottom. Specific was in addition. This is the tax condition. The other would be tax also. Submissions completed. We are reserving the judgment. We have narrated the facts so that if there is any mistake, it will be pointed out.
Timing item 2.
May please, your lordship.
Yes.
Lordship, in this case, lordship, improving opinion is case 41. Petitioner declared for now 66 to 71 still. Lordship. The ancestral parents and siblings migrated to India from East Pakistan in the year of 25/6/1964, my lord. In respect of relief eligibility certificate, my lord, that is, place, my lord, 12. Place 12, my lord. Place 12 is the type copy, my lord, vernacular is place 14. My lord, in place 14, in point number 5, date of arrival in India and place whereby date is 25/6/64, 1964, my lord. Although, my lord, this document was not produced before this tribunal also, my lord, was not exhibited. My lord, in the morning time, my lord, I have checked and verified the LCR, my lord. We could not find out the, my lord, reference. LB report, police verification report, my lord. Okay, my lord. Okay, police report,
But that means you have not seen the record. Come to page 42. This is mentioned as exhibit 2. You have not read the record.
It's 42.
This is your document, page 42. If you read, exhibit 2 is the, exhibit 1 is the land document, exhibit 2 is the certificate on the Naumgra
Yes.
of the Panchayat. Oh, I'm sorry, I read it, I wrongly read it, I'm sorry. Land document of father relating to rehabilitation scheme.
The 6 acres of land was given by us to the government, my lord. In the year of 1968, my lord.
before settlement. In this regard, 1,000 rupees loan was paid to construction of the house, my lord. That is the agreement in Exhibit 2, my lord. Bond, this pays, this is the Exhibit 2, my lord.
Where is that document here?
Document, my lord, Annexure 1, document relief eligibility certificate, my lord. Relief eligibility certificate, page 14. My lord is the original, and my lord, in para number 5, date of arrival of in India and the place with entry. The date is 25/6/1964, my lord. Who came from East Pakistan due to religious persecution to India, my lord, on 25/6/1964, my lord. No, this document is not before the tribunal, my lord. Not we executed the bond, my lord. This is the exhibit number 2.
But still you were given the opportunity of registering. You did not register.
Already registered, my lord.
Where is that?
Yes, my lord, last page, page number 48, Annexure 7. Purva Turisi.
When you have registered, why did you come to court?
Not, not a challenge is, my lord, I am not a 60 to 71 SDM. I am before that from, my lord, from East Pakistan. That is why, my lord.
Page,
Yes, 48, Annexure 7, last page, my lord.
Last.
Huh? Very funny, important, very nice. Revision to put now here.
Yes, record for that.
Hello?
I have no question. Please answer the last 12 question. Okay. You could not say anything about this. Father. See. What defects in the proceedings? Number one, the evidence of PW1. The manner of giving. It just says in the last that it is exhibit 1 to 5. It doesn't show which document. Now, please come to page 57. Back page. Mr. Vishwas, look into it. Look into this.
I think you go. Bond of member. Within my family members, voted in the prior proceeding to one. You can stay with me.
You have seen that page,
Yes.
how the exhibits are noted. And in the front, the three page. In that, the flag on the 50, page 57. The evidence part, exhibit so and so, 1, 2, 3, 4, 5.
Yes.
You seen that?
Yes.
This is how documents were proved. This is not in accordance with law. And in the front, there documents are there. No document has been exhibited. All the photocopies.
It is a fact that some documents have not been exhibited in the.
No. Even the documents presented were not proved. You look at the documents in the front. The documents are there. The signature of the title is not visible, and those are photocopies.
Nine. Well, there was some mistake, no doubt, but it is a fact that he came before 64. Yes.
Once the statement is there, we can't communicate. Doesn't refer to in his evidence doesn't refer to the migration.
Extra কোনো সাইজ দেবে, 10 বছর হয়ে গেছে। Section 1/4/2016.
This is 26.
10 বছর।
I completed 10 years of registration.
You take that benefit.
Yes, if now they treat me as a citizen of India, as per the decision of the clause 6,
Observation.
okay, then probably my problem will go over, at least
10 years completed.
10 years completed. But even if fate is that he came in 64 with the refugee card, all these things are there. But because of ignorance, it was not been able to put in the code below. Time and again, Honorable High Court also given opportunity to go back. Even then, its same position is there. That's nine. As your lordship pointed out, exhibits were not signed.
Any statement anywhere when his father or mother died?
Hmm?
Any statement anywhere when his father or mother died or when they were last alive?
Eh? अच्छा तो बाबा WS नहीं WS तक
This 29. This 29.
नहीं चलो वहाँ से इंडिया से निकल आना
In WS, there is no statement. In WS, there is no statement when did father died, mother died, whether they are alive or not.
Please read the written statement.
Yes.
What does it disclose about his parents or grandparents?
It says statement WS, my lord, that the opposite party is an Indian citizen by birth, Indian citizen residing at so and so, Gauhati in the district of Sonitpur, Assam, and born and brought up in above mentioned locality, having both movable and immovable properties in his name.
He does not give the name of the father.
Born and brought up in the above mentioned locality.
He does not give the name of the father.
Father name is there, fellow. The father of the opposite party is late Banka Bihari Sanda.
Where he died?
He died, nothing.
That is not there, madam. Late, he has said late Banka Bihari Sanda, but was original resident of so and so, Gopur, Moja Gopur, district Assam. That father of the opposite party had come to India in the year 1964, Pakistan, East Pakistan, now Bangladesh, due to communal riot there at the time, and used to stay so and so rehabilitation center at Tezpur. Thereafter, government of Assam allocated a portion of land on 6 biga so and so by exhibiting a bond. In 1968, the opposite party, Pradeep Sanda, had cast this valuable vote in the 1985. the opposite party has got some relevant papers and documents which will ascertain that he is bona fide citizen of India under the circumstances of opposite party could be treated as not foreigner. The opposite party was born in village Tarkura, post office, Gohapur, Corporation, district Sonitpur in 1968. But interestingly, do notice has been served to Honorable Tribunal of the Sonitpur. That's only, he has not responded, he is going for a try.
Right. Mr. S.C. Biswas, counsel for the petitioner, and so for the respondents. Next one. By filing this petition under Article 226 of the Constitution of India, petitioner has said opinion dated, this is at page 40, dated 23/2/2016, passed by so and so in FT case number so and so, DC case number so and so, thereby declaring him to be a foreigner of force, in stream between 1/1/1966 to 25/3/1971, and the petitioner was directed to register his name before the registering authority within a period of 30 days from the date of the opinion, as per section 6, capital A, within bracket 3 of the Citizenship Act of 1955, and part Roman 4 of the Citizenship Rules from 2000. Next one. The learned counsel for the petitioner has submitted that the father of the petitioner, namely late Banka, B-A-N-K, Banka Bihari, B-I-H-A-R-I, Chanda, C-H-A-N-D-A, had migrated into India in the year 1964 due to communal riots in East Pakistan. And thereafter, the government of India gave rehabilitation by way of allotment of land to the father of the petitioner, in the in 1968. Right. Rehabilitation bond. Executed on 20 March 1968. Accordingly, it is submitted that there was an inadvertent error in not exhibiting the Relief eligibility certificate, which discloses that the father of the petitioner arrived in India on 25/6/1964. Along with three other dependents. And therefore, he praised that an opportunity be granted to the petitioner to prove the migration, the document of his father relating to migration. Next paragraph. Third contract for the, just send back the records. Third contract for the journalist manifesto for the border and active matters is submitted that notwithstanding that, notwithstanding the plea that has been taken by the petitioner in this writ petition. In response to the queries of the learned tribunal. This is available at the back page of page 57 of the PCR. The petitioner is stated as follows. Copy this page 57 back page. Right, what's the records? Whatever you need to write. Accordingly, comment is submitted that there is no error committed by the learned tribunal in passing the incline order. And in view of the said addition, the prayer made by the learned counsel for the petition. Cannot be exceeded to by the state. Next paragraph. On a query of the court, the learned counsel for the petitioner has submitted that pursuant to the said opinion dated 23/2/2016. The petitioner had registered himself in discourse about his wife and children. By making an application dated 1/4/2016 and the Special Foreigners Regional Registration Officer 22, had registered the petitioner as a foreigner of the stream of one 1966 to 25/1971. By registration number capital PZ oblique FRRO oblique 16/420 dated 1/4/2016. Next one. On a perusal of the records, as the court finds that the petitioner on the query put by the learned tribunal had stated that he had not submitted any document showing the name of the family members prior to 1968. And having observed that neither in the written statement nor in the evidence on affidavit filed by the petitioner, he has disclosed about the rehabilitation eligibility certificate. This court in exercise of statutory jurisdiction did not appreciate the documents as a court of first instance. Moreover, as the petitioner has already been registered by the special FRRO on 1/4/2016, pursuant to the impugned opinion dated 23/2016. The petitioner would be otherwise eligible to avail the benefit of section 6A of the Citizenship Act of 1955 in terms of the mandate of the said provision. Accordingly, the nature of relief as claimed in the petition cannot be allowed. Accordingly, this petition stands closed on terms as in terms and observations as made hearing before. There should be no orders to consider. This was, we are not saying dismissed, we are just saying closed. This is exactly, yes, here. But this is very serious. The lawyers handling foreigners tribunal matters do not know how to deal with the issue, how to prove. This is very bad, very sad in fact. He could have got the benefit.
If it is remanded again, my lord, he will only suffer. If it is remanded again, my lord,
Because we'll have to set it aside.
yes,
The problem is that we'll have to set that aside. Just remand. That will give you again.
yes, another first litigation, he will suffer, my lord. That's why already registered 10 years is done. Benefit.
Item 4.
May I be the Lordship? Lordship, the petitioner was declared as immigrant migrant on in FT case number 154K of the 2026. Lordship, and the peruse Lordship, annexer 1, page 15. Here, name of the great grandfather was recorded in serial number 759, house number 24, Hassan Ali. Hassan Ali is the grandfather and late Kujo Sheikh was the great grandfather of village Nolonga.
Annexer one, page number 15. Also, thereafter, Annexer two, page 16. Petitioner's grandfather name was there also. Personally, same house number, same village. Father's name like Huzu said. Annexer two. That's it. Thereafter, Annexer three, page number 17. The name of the the name of the father of your petitioner was recorded as Hasan Ali instead of Aman Ali. His name should be Aman Ali, but it was recorded as Hasan Ali. And to prove that whether the total list of 1985 and 1970, they are same same lineage. The name of Aymana Bewa, wife of Hasan Ali, at Annexer 3, serial number 698. And in page number, in Annexer 2, total list of 1970 also, Aymana
Is there any
Khatun was
voters list of you along with your father?
my voter list
Along with your father? Not there. You need a document except for voter list to connect you to your parents.
Nothing. The voter list of there is one voter list, but it was not in the part of record of this petition, Lordship. I got one of the copy, Lordship. Lordship, second page at serial number 745. Next page, Iman Ali, son of Hassan. Then at 747, Aman Ali, Hassan. Then my name is here. Next 7 my name is here. My wife name is here, Maleka Khatun, Aman Ali. My mother name is here, Maleka Khatun. Again, my mother name is here in the photo list of 1997. Maleka Khatun is here. Annexer 4, page 20. My father got demised in the year 1996, so his name was not in the photo list of 1997. When I was demised as the photo in the year 2005, Annexer 5, page 2022.
Okay. Yes, okay. 2004, 5, okay. Okay, annexer 5 is 22. 24. 22. 5 copy, particular for 25. Mamanado. Father in Mamanado. Total is of 1997, annexer 4 also, my mother name is here, with my father name. Mamanado.
Voters list are different places. Voters list all voters list are different places.
Lordship, my great grandfather were of Nolonga village. Then in the period of 1985 to 1970, they shifted to Udusar. Then after the demise of my father, my mother again shifted back to her ancestral place, that Nolonga. Then thereafter, I shifted from Nolonga to Rutnoy. 1970. Iman Ali, that was my brother of my grandfather. His name was also recorded here also in annexure page 17 also. Hasan Ali is my grandfather, and their sons are Iman Ali. That is my brother of my father's brother.
See, your only connecting document is that computer certificate. Okay, it becomes inadmissible.
Because of my original ancestor place was in Nolonga.
Getting any link. Certificate on which you are relying becomes ineligible because of the use of state emblems. Please, Mr. Payne, what do you have to say?
In fact, the petitioner before your lordship is case based on WS, you can see, my lord, in WS, his claim is that is this grandson of my lord, this Hassan Ali. Hassan Ali. Now, the petitioner has to link himself to Hassan Ali by some document. Because the father, projected father Aman Ali, his existence is only from 1989. 89 or 85. 85. 1989. So, 1970, the petitioner's grandfather is shown to be at Nalanga village, and he is Hassan Ali, and his, as per him, the petitioner, the grandmother is Aimona Khatun. Now, to link the petitioner, grandfather along with two mother father, there is no document at all, because the 1985 voter list it is document, my father's name was wrongly recorded as Hassan Ali instead of Aman Ali, Joseph. Whereas in the lordship, the voter list of which I have submitted before your lordship, 1989, here my name was, father name was here is lordship. As Aman Ali, son of. So it's this 85 voter list was not exhibited. Yes, voter list was 85 was exhibited. 89 was not exhibited. 89 was not exhibited. Exhibited, lordship, in case it was exhibited in the trial court, but it was not in the part of the court, lordship. Somehow it was left out. Now the only linked documents is the consent certificate, which is not proved. And even though if we accept, see the 1985 voter list, it is not a certified copy. I mean, it is not a certified copy. However, the serial number 706, 708, the projected father is shown to be Hassan Ali, page 19, my lord. Projected father is shown to be Hassan Ali and Malika Khatun, mother. Lordship, in both consequent voter lists, 1997, 1970, 1985, and 1990, and 1989, both my father name and my father's father name are there. Iman Ali's name was there. To make this sequence of step. And both are son of Hassan Ali. Now, to link himself with the petitioner has submitted, there is no common voter list of petitioner and projected father. Just don't come.
But the name of AGP is indicated in the judgment. But here it is, the order sheet and all, it's not clear whether, not mentioned whether it was, the government was present. And this is mentioned as deposition of DW1. Loss is also not indicated. Tribunal question is also not mentioned. That is also not mentioned. That is a tribunal question.
Well, yes. Yes, ma'am. I'll go through. Yes. Yes, ma'am.
Division bench item 1, 2, and 3.
There is some development, but it's not
Not
yet
that.
over. It's not yet over. You know.
We anticipated that.
Well,
What we are trying to think is, we are just thinking about, will it be appropriate for us then? You see, every year we have these stakeholders meet. If the government is not really interested, the High Court opts out of it, and we report it to the Supreme Court that since they are not doing it, Mr. Chaudhary here, Mr. Das, and we too, we are the only 4% and Ms. Chaudhary, we are the only 5% interested. We opt out of it. Let there be no representation from the state. We'll inform the Supreme Court, we end the matter, we close this chapter.
no, but, I would humbly say, Mullah, that in fact, logic may not consider that the state is not interested. Mullah. In fact,
No, because if there's no policy, you see, there's nothing is going to get effect. Number one, the education of the children, that is being hampered. The what do you call, the progress, the status of the children homes and all, those cannot be effectively monitored.
that's true. That's true. Mullah. That's true. There is no second opinion. Lots of questions.
According to your letter,
No, no.
the views have been received from all departments and both draft of the 2022 have been sent to the legislative department. When?
It was, Mullah, the policy was sent on 8th of July, on 8/7/2026. Mullah, I have on telephonically, I have asked them after receipt of this letter. Policy was sent on 8/7. And Mullah, the rule was sent to the legislative department on 16/7. Look, I have asked about the further procedure because of the ongoing assembly this session.
We understand, but if really this thing is,
They have
if the state is not interested,
well, I'll not submit. No, I'll not submit that the state is not interested. Lordship may kindly consider for the time being. Well,
we
in
will
fact,
just make an observation, the child is not our future.
no, child is our future. Future, that we cannot deny. But in fact, I have asked them because the anxiety, all of us have the anxiety.
See, Mr. Nath, your sincerity. Come to the paragraph 10 of the last order.
Lordship.
I'm not saying you as Mr. Nath.
No.
Come to paragraph 10
Yes, Malad.
for last order.
I'm on that, Malad. It is very clear that the state shall place before this court on a next date fix a comprehensive status report indicating the precise stage at which the proposal presently stands, the steps already completed and definite timeline within which the rule and the policy are proposed to be notified.
And your answer is this, not even a date when it was set.
No.
Why should we look into this? After this paragraph here. I have asked the date for that purpose.
Malad. In fact, immediately on receipt of that,
See that case will approve.
immediately on receipt of that, Malad, I have asked them that you have to indicate the date.
That is, I'm not saying you
Lots
should not.
Logical.
And you made a submission on last occasion
Malad.
that additional chief secretary, women and child development department is personally monitoring it.
Lots.
And look at his personal monitoring.
What they have expressed, Malad, that
No, see,
Lots.
answer is, you made a submission that he is personally monitoring.
Lots.
We are satisfied.
Malad.
A person like an additional chief secretary is personally monitoring.
Lots.
So we pass the remaining, having regard to the state statement.
True.
Every word is having its meaning, having
Absolutely.
regard to the state statement.
Absolutely.
In the expectation that
Malad.
authorities would treat the matter with the seriousness that is deserved.
Lots.
The court refuses for the present, refrains from the present, from issuing it should be, there is some mistake. Court refrains from the present for issuing any coercive direction.
Lots.
Okay, then paragraph 10.
True, Malad.
And should we not pass any coercive order based on your communication today?
Malad, finally,
Just
Malad,
tell us that as a officer of it. Should we not pass any coercive order against this additional chief secretary?
Malad,
They don't have even time to read our orders.
no, it was made known to
Then
them.
what is the response?
It was made known to them. It was communicated.
That's
Malad.
what I am saying, why should we not pass an coercive order today?
You see, we have earlier we have stated
Malad.
that till we don't do it, you please notify that the central rules will be followed.
Well, in fact, central rule, I have asked that, but the rule, the provision provides that until and unless the state frames the rules, the central rule will be followed, and it is being followed, Malad. It is, they are doing it, Malad.
What is that for?
The model central rules of 2016 is being followed. This has been done, Malad. I have asked them.
It's okay, that's fine.
Lots.
That it will be a-
You give it the book.
I have the paper. I have. But 110.
Under 10 of the rules.
Of the act, power to make rules, no? The state government shall, by notification in the official gazette, make the rules to carry out the purposes of this act, provided that the central government may frame model rules in respect of all or any of the matters with respect to which the state government is required to make rules, and where any such model rules have been framed in respect of any such matter, they shall apply to the state notarius potendis until the rules in respect of that matter are made by the state government, and while making any such rules, they conform to such model rules. In particular, and without prejudice to the generality of the foregoing powers, such rules may provide for all or any of the following matters. Logic. And the rule is there, the model rule is
Already there.
in this particular book is there. Logic. So at present, in absence of this logic.
You can
Already passed.
recalling it. 25 stakeholders meeting was the month of September.
Logic.
And we are expecting that we say our rule is already there.
Yeah. Logic.
Now the next stakeholder meeting is in next week. One. In national level. I think who are the other things? I think Assam is not having the.
There are few states, but Assam doesn't. Rajasthan was among the first of them to frame the rule. At present, that I'll have to check up.
Assam and some more. And what are the other issues? We'll not proceed in this matter until and unless these rules are framed as policies in place. Then they still follow all this monitoring, whatnot.
The audit report has been completed, it was submitted, and
That's fine,
copy has been given to them.
that we have seen.
But you see, this exercise of getting the audit reports and all, after that, what? You see, you don't have a rules, that can be implemented.
Okay, you assume that you can be implemented in terms of that, but where is the side policy?
One of the policy and the rules, one of the same state. Along with the rules, one of it is also under process.
It's a very specific policy.
See from the last order, also, presently. The SK Das is not there.
No, my lord. Maybe his junior is there.
The application,
We record your presence,
Lordship,
Miss
D. Mohanto.
D. Monto. Instead of, you say it's D. Mohanto, the current council enters the appearance on behalf of Mr. H. K. Das, non standing for the High Court. Okay, for the last part. Pursuant to order dated 4/6/2026. From the Learned Senior Government Advocate has submitted that he has received the instructions to the effect that the views of all the relevant, referral departments has been received in respect of the draft Assam Juvenile Justice within bracket care and protection of children rules, which is yet to be notified, and the Assam State Child Protection Policy, and they have been sent to the legislative department for necessary vetting. And thereafter, the matter would be placed before the cabinet, the state. Next part. Though
Well, there are two states. I could just find Assam and Kerala. Otherwise, most of them have no. My lord, just one submission. My name is recorded as amicus. I'm not the amicus. I'm representing the petitioners in the item number 2.
okay, okay. This, item number 2 is that PIL
60 of 2019, my lord.
Mr. M. Chaudhary, not as an amicus curiae, but as legal counsel for the petitioners in PIL 60 of 2019. Okay. Next. in view of the inordinate delay in the framing and notification of the draft rules and the state child protection policy, on a query of the court, or the learned senior government advocate has referred to the provisions of section 110 of the Juvenile Justice within bracket care and protection of children bracket close Act, 2015, and submit till the rules are framed, the model rules framed by the central government would mutatis apply to the state. Next, accordingly, the state is put to notice that in view of the inordinate delay in the giving of the giving a notification of the Assam Juvenile Justice within bracket care and protection of children bracket close rules and the Assam State Child Protection Policy, why an appropriate order should not be passed by this court to put all the stakeholders to notice that till the state frames its rules, the model rules framed by the central government should mutatis mutandis made applicable all this to the state. Next slide. As the in view of the categorical direction issued in paragraph 10 of the order dated 4/6/2026, the written instructions received by the learned senior government advocate from the Deputy Secretary to the Government of Assam, while Women and Child Development Department not being in adherence to paragraph 10 of the said order, is not accepted and returned. Next para. On the next date of listing, on the next date of listing, we request the Secretary to the Government of Assam Legislative Department to appear through video conferencing mode and to apprise the court about the to give us the to give the court information in terms of paragraph 10 of the order dated 4/6/2026 regarding the comprehensive status report indicating the precise stage at which the proposal for the Assam Juvenile Justice within bracket care and protection of children bracket close rules and the Assam State Child Protection Policy, presently stands. We are showing these directions because the court has been apprised that the matter is pending for vetting by the legislative department. Next, we request the senior government advocate to transmit downloaded copy of this order to the legislative department of the Government of Assam. In this order to the this order and the order report 6/27 to the legislative department Government of Assam to bring the set two orders to the notice of the set authority. Next paragraph.
Any idea?
But by which, after,
Accordingly,
no, after 31st, they said that after 31st, they will start it, they will do it.
The court is inclined to put it on record that the state of Assam is only one of the few states which has till date not framed the Assam juvenile, not framed the juvenile justice within bracket care and protection of children bracket rules and the Assam state child protection policy. Unless such rules and policies are in place, it would be an exercise in futility to give further directions for implementation of the juvenile justice within bracket care and protection of children bracket Act 2015. Next step, list on. Tell us when to list it again.
Malad bhai, kindly keep it after 4 weeks.
keep a date.
Malad,
Because it is too sure hand.
Malad.
We are expecting and still will expect that on our next day we have to see.
Lots of
draft.
I also, Malad, I'll be very happy to say that, Malad.
Make it sometime in August because September is the stakeholders meet.
Lots of. Let it be on 2nd of September, if not.
No, because we by then we'll have to communicate with the Supreme Court.
Lots of. That is it.
Personally, I would like to opt out.
Malad. On 24 to 25th, Malad.
Okay. 24th, 5th is Tuesday,
24th, lots.
5th, 25, 8, 20.
Malad.
There's no point
Lots of.
in doing that exercise when the state does not have a policy. We can't implement those orders. And the education department has not joined. For that, we have an information now.
But here consultation has been done with them also. Consultation has been done with all the departments.
You have to tell us on the next date. We are specific on it, whether the education department has been consulted.
Yes, Malad.
No, no,
I'll-
I think there are earlier the first degree.
Yes,
We have said that.
Lots
We
of.
specifically want to know if the education department has vetted it.
Malad. In fact, they have indicated all the departments. I'll specifically.
We are more interested in education.
Malad. Lots.
There's nothing here.
Item 3.
Let me close it now.
Started shelter homes at that particular point of time.
Yes.
And the juveniles have also been removed from all the. Of course, if you also want to look into the entire issue of, why some districts still do not have shelter homes, that of course will come flowing from this because it is a provision of.
Because once that is in place, we
Once that is in place, we come.
But I have received a report. It indicates one of the status of the observation home and the childcare institutions, shelter homes in the district. District wise.
Let us keep
Lots.
pending the time, let us see what. Or should
No,
we-
you see, today only, I have been informed by someone
Malad.
that in respect of the shelter home or observation home at Jorhat,
Lordship.
it is for several districts and it is overcrowded and is not in a good shape.
Jorhat, my lord, we have observation home, one observation home, government run, and 3 shelter homes.
No, but today only somebody told me that it is not in a good condition, it is overcrowded.
It is,
And it is,
there are only 5 or 6 districts which have the shelter in the state of Assam. And so they are, all the districts are divided and the children are taken from different districts and put in, wherever is the.
That's right,
the
but-
closest district.
No, no,
specific
adjacent,
information for this.
in
The adjacent, three
adjacent.
adjacent districts. As per the act itself, the act says, that act permits that 2 or 3 adjacent districts
We
can be taken.
understand, but the issue is that if it is overcrowded, then how do we get the information about that?
I can find some, I can tell my officers to find it about the act
Malad-
status. My learned friend can also get
The,
the information.
the social audit report, which is already on place. It is already placed before your lordship, that indicates the status of the shelter homes, observation homes.
There was a chart which I had produced before your lordship on 2nd of April 2026. There it says that Jorhat has 62 inmates. As per the information received by the district, as from Assam.
It is equipped for how many?
62.
No, it is equipped for how many?
Oh, that your lordship does not say, it just says it is, I'll just confirm with you. Definitely, your lordship.
And audit report, after audit report, if there are overcrowding or other, if somebody brings to our notice, because you cannot monitor each and every.
Lordship.
Sometimes it may go high, sometimes it may go down. And these are the list, my lord.
Your lordship, in that. Lordship, in that chart which I have produced on 2nd of April, if your lordship will, because I think it's flag marked as flag Y in your lordship's file. There at page 10, the details of Jorhat district are given. Your lordship. If your lordship, because there are 14 rooms and 62 inmates. 14 rooms, 62 rooms,
Literally overcrowded.
definitely. So 4 per room.
Any return
Mandated, mandated, I'm not very sure because I'm
And there is
just check up what is
prescription.
the, I'll.
what should be, then see like this something. Designs are there, whether any design for this different homes are crowding or any statutory mandate or mandate by, I don't.
I'll have to just check this. I'll check it out.
Look. Otherwise,
Exhibition may sometime, every Sunday.
it may come, it may come.
Correct.
So this particular list will indicate the observation home and the childcare institutions in the entire district. Logic.
Uh, You also take it from the last order of 2/6/2026. Also present. Instead of Iskandar, here it will be.
No, Mr. Das was appointed as an Michael, if I'm not mistaken. Yes, the last.
Yes, yes.
One or two orders. before.
Please, Council, on behalf of Mr. H. K. Das, for the High Court. Mr. D. Nath, the senior government advocate, and Ms. R. S. Chaudhary, learned technical for ESLSA, and Ms. CGC, who's there? Ms. N. Devi, learned CGC, appearing on behalf of Mr. R. K. D. Chaudhary, learned DSGI. Next one. This was produced by you.
Logic.
Mr. The learned senior government advocate has produced.
You don't deny, no?
Right.
Copy of letter dated 17/7/2026, issued by the State Child Protection Society, Assam, including therewith the chart depicting data in different districts of the state of Assam regarding observation homes, shelter homes, within bracket, childcare institutions. That's what we said. Communication is made a part of the court. Next paragraph. List again on the same date,
24th.
25, 8,
25.
25, I have some difficulty and how to on that paper, some of the case.
just ask somebody to, just,
I'll ensure someone here to assist you.
just remind Mr. Nath, they will inform me, will record your absence, but we'll take up the matter because Tuesday is there. The September is the stakeholders meeting. Not to do it fast.
As per your logic, I have no, it can be taken up together, there's no difficulty, I will just kind of accommodate. Someone will be here to assist you.
Just, even if somebody is not there, just give information either to Ms. Devi or Nath, will take note of it.
You'll be obliged.
Single bench, item 1 for
May it please your lordship. Lordship, tender my apology, Mr. Das is not available today, estimate council, Mr. Das, your lordship. He is here. Hello, as per the last order, your lordship, it is copy to begin. But we could file an affidavit today only in the morning. We have given them copy. I have just handed over my copy. Order to. 2600 rupees. 2600.
You see, at random, we were turning pages. At page 440, is a record of your discussion. We think that insofar as this issue is concerned,
441, yes.
now you have to make it clear as to what would be the, what would constitute an appearance. Otherwise, what happens is that A is the presiding officer. A letter comes to him from the department or from somebody saying that in the last month, when did the AGP appear? Now, if this question is asked to me, I would not even remember yesterday which government advocates were representing the state when I was presiding. And therefore, according to you, what constitutes a daily appearance? Either 1 or 2 cases or 5 cases, or the daily appearance from 10 to 4:30, whatever the time is. And what work would constitute the AGP appearance? Instead of members, you have to devise it so that the members have clarity in issuing it.
No.
You see, and there's always a second point. You see, when, for example, in this bench, at times, whenever you are not there, but somebody says that Mr. Das is here, Mr. Nath is here, I record your presence.
Got it.
You would also ask, but incidentally he was out of session, otherwise in the earlier bench, I would have recorded the name. Bench for presence. It depends on the presiding officers and how they react to the presence.
In these courts, Lordship may kindly appreciate, Malad. In these courts, Malad, only one GP, one court, one GP is there.
So we understand.
And if the
But
GP,
you have to inform the tribunals of the guidelines that they will be appearing for the entire day. His appearance, then you have to say that his appearance constitutes his presence in the tribunal for the entire day. Or if he is out before the tribunal time, then he will have to take a leave. So that clarity has to be given.
so
You see, otherwise what happens is
that has to be indicated somewhere.
just wait. Last week we just the partner. Yes, 18/170. This is today's matter. When we are taking out the division bench. You see, read the order dated 18/170, last order. Read it loudly so that I'll tell you then what has happened.
Lordship.
Just read loudly, I'll tell you.
The respondent presents cross and discharge, hard argument. 6/30/31/2017 for judgment.
So he was cross-examined. Now there's a yellow flag there. Yes, see the back page.
Lordship.
You see, this is not cross. This is not cross.
DW on oath.
Examination on oath. You see, the language is examination on oath. So therefore, an evidence is there. Apart from the evidence, the tribunal gives an oath and records the statement again.
But in fact, this is where he has written, this is evidence in chief.
That's what I am telling you. This is examination in chief by way of evidence on affidavit. Now, next page is again the examination by the tribunal. Correct. Now, everything which has been stated is affirmed here. So and so, so and so, so and so. Therefore, what is stated in the evidence is affirmed. Now, look at the opinion. Opinion will be last, I think. This is the final opinion.
15 to 17.
Yes. Now look at the first line. Present, AGP present. Correct? AGP is present.
Yes.
AGP's presence is not recorded in the order. It is not recorded when the examination takes place. And his presence comes in the final opinion. And then can you deny his fees?
In none of the orders, presence of the AGP
Is recorded.
shown.
So this is what is happening in reality. And this examination, which you saw, back page of 17, look at the last date down below, 18/170. So it is not that it is written somewhere else. This is what has been recorded. And in the order sheet, it's falsification of records. It says cross-examine, whereas here it is examination.
18/117.
This is falsification of records.
In fact, on the same date, the course was done, discharge and arguments were also hard.
Also right. So this is what is happening, and we can show it from a lot of records.
They have to think on that, because if they have to think on that, because
We say you have to
They
plug
have-
that hole.
they have decided not to give fee, but ultimately that has some mechanism has to be there.
So you have to plug hole.
So
Now this
in here also, Manoj, they have indicated that no hearing fees on that day. Or sometimes Lordship has indicated page 440. They have considered the hearing dates. And the AGP attended the tribunal only to issue notices which cannot be treated as duty, etc.
you see, you can ask that to your to any of your APPs who are there in the district or in any other CGM4. During our times, the duty of the APP and the DP was to go to court, write notices for issuance of summons. So that is a part of their job. And those are all office duty, which they can do at the office, they can do it at home. And that is not treated as at our times, it was not treated as a part of the court appearance.
I have also seen, Manoj, they used to take the record and then write the notices.
Write notices, but that is not treated as a part of
Their
court
duty,
duty, court
their
appearance.
Court work.
But what I'm speaking is of naturally more than 10 years back. So how times have changed, we don't know.
No, still APPs are writing, Manoj.
They're writing.
I'll indicate, Parab, because they have decided to take up the matter with the judicial department. I'll inform Manoj.
But
Well,
there, it's not good.
the inspection reports, we have received, no? Those reports we have not annexed here, but I have copies, no?
No, but the infrastructure is still not done.
That's true, that's true. The reports I have received, Malad, in fact, the report is voluminous, that's why we have not given. I could not give, Malad. I have made 3 copies, Malad. रिपोर्ट का पेज नंबर दिया है तो लिखी बोले बोल 89 पेज ऑफ रिपोर्ट शायद बिना जी ना एक कलर काटी गई कलर लोग जो काटी गई এটা এখানে আপনি করে বাইরে
It is a supplementary issue. And which is the practical aspect of it.
all right
There are judicial pronouncements which says that if the workman is a contractual or a outsourced employee, then the employer cannot give any direction how to work. He'll take instructions only from the employer. SBI canteen case and then all this says that if the employer gives the instructions, then he is the employee of the institution. And therefore, that if it's the outsourced concept where the appointment is to some vendor, so therefore instructions will come from them. This is affecting, amongst others, your health department also, because you are outsourcing drivers to ambulances to others. Now, if the hospital management starts telling what to work, how to work, then he becomes the employee. Now this, we are also getting affected because of the fact that the
Okay, okay. High performance. It is difficult, for sometimes if supervisory directions cannot be given, it's very difficult to get job from that. Come on. They used to come at their own time. They can direct the vendors if they are engaged to some vendors, some contractors. Mhm. Mhm. Yes, yes. And that's good. SBI company society. Logic on 2/6/2026, logic has passed various directions. Pursuant to that order, we have filed the certificate and all of the inspection reports we have received and reports we have placed. Now we have to work on that. As regard the appointment of government pleader and GP, Malad, that in the meeting, Malad, a decision has been taken. Various issues are there, Malad. There is no system of comparing with the original, Malad. Normally we used to do that. Compared with the originals, that we used to do normally. Compared with original করে বলে original ঘুরাই দিব লাগে। compare না করেনি। compare করবে লাগে। No seal. No seal. No seal. There is no seal in it. Compared. Exhibitor marking. All Xerox. No Xerox. There are not even markings or exhibits. No exhibit markings or Xerox. They are all Xerox copies. They should have compared these documents with the original or the certified copy. Logic.
Then copy.
No, one SO is there, on a schedule of rape is there. The one cannot. One cannot.
Common parlance, what we call it is financial today.
Prudence. There is no prudence.
They have to balance, try to balance.
That's right.
At the end of the day, actually, absolutely. Ultimately, at the end of the day, it is our money. It is our money.
No. And you will come. One 300 is, 300 is, my son, 1,000 rupees, 1,055, 1,080. Okay. 13,000 for each, a pair. To our hand.
6,500.
Okay.
6,500 both.
Okay.
Excellent. Something whether it comes from within. One has to have that. Excellent. Same yardstick applies to institution and expenditures also.
There is some issues you'll also, whether you'll also like to take up today or not. First, you'll also tell is regarding the retention of the members, you'll also, fresh retention orders. And there are more, and so salaries are pending since May 2026. Yes, sir. Their letters been addressed to the registrar, you know, so that salaries have not been paid since May 2026, and there are no fresh retention orders. But I'm told that the state has already written to the government, Union of India, and the some file is with the Ministry of Finance, Union of India, and that is awaited. And they also approach the finance because of the receipt of the instruction from the Finance Union of India. They are not in a position. The Home Department is not in a position to seek. Yes, Your Lordship. Yes, Your Lordship. Then the authority concern has to be intimated regarding the retention of the retention order, because salaries are not being paid, Your Lordship. There are several letters, Your Lordship. That means it's addressed to the registered judiciary, saying they have not been paid. The letters have come, Your Lordship. Letters are here. I can provide you, Your Lordship. They have sent some letters from the members. Yes. Then it has to be intimated, Your Lordship, to the authorities concerned to pay the salaries, Your Lordship. But there has to be communication, Your Lordship. No, I have spoken to the department people, the secretary. They informed that they are awaiting the instruction from the communication from the Union of India. Once, and that is why, although from our side the finance department has been approached, they are not entertaining because the union's communication is not clear. But then I have to ask again, because today when I discussed, they said that the Union of India, the Ministry of it is sent to the Finance Ministry. And it is lying with the Finance Ministry, nothing has come from them. I'll talk to them again. Or you can listen, both of them. There are 5 to 6 letters addressed to the registered judicial regarding non-processing of salary bills. Maybe they are not aware that
Yes, your lordship, that's correct. Yes, your lordship.
I'll definitely, but I'll talk to them again, because I have asked them that salary for the, I'm not able, madam. I'm not able.
It must have come from Mr. Chaudhary, senior counsel, Mr. Chaudhary, your lordship. He must have placed. Okay. Okay.
Well, I'll ask them, specifically I'll ask them.
And it has to be
Because-
communicated to
Because
the,
today they have informed that already from our side, we have written to the Government of India, Union of India, filing with the Finance, Ministry of Finance, Union of India, and nothing has been received by us. We have also sent reminders. Then the matter will be different. Not true. Yes, please. Yes. And that is why our finance department is also not entertaining, treasury officers are not entertaining the bills. But I'll ask them again.
even the treasury officer has rejected the bill,
Yes,
your lordship, as I've been informed, your lordship.
Yes,
Yes, your lordship, that's correct, your lordship.
I'll definitely. Oh.
Yes, your lordship, because the earlier order ended on 22nd of May 2026. May, we are in July.
No. Retention হবে তো ইউনিয়ন অফ ইন্ডিয়া কথাটা সার্টিফিকেশন পাবে তো রিটেনশন করে দিতে কি প্রবলেম আছে
On the, actually last order was passed, your lordship. If there is, if I'm allowed to, your lordship, there is another issue regarding supply of GLT, your lordship. If I'm allowed to place the later, your lordship.
কিতাপ দিব দিছে এইটো
No, tomorrow it should be discussed. As needed.
Oh.
This is a letter, your lordship, written from the law house, your lordship. Issues are down below, your lordship, the issues which they wants intervention, lordship. Regarding point number 1 and 2, down below.
They said in respect of seven members or
Whose names are not included in the earlier supply order.
not included in the order. And volume 7 and 8 of GLT to all hundreds. As these were published subsequent to the order, original supply order.
There has to be a fresh order in regard to point number 1 and 2.
Okay.
Yes, your lordship.
Since they have already possibly returned to the joint secretary. I'm just thinking about that, how the tribunals will manage these books, because the GLP.
Yes, this is what is come to.
Retention on
Here the come to us.
retention order. Next will be one only order on. No,
This was the second. This was the second. That's why it was placed before me.
on the last occasion, when matter is listed out. This is a letter your lordship is seeking retention, fresh orders. We have asked for, we have requested kindly to accord necessary approval for extension of terms. We have written it to the Home Affairs,
There's an order of approval also.
Home Department.
You just communicate with the home, they will tell you.
I'll keep this note. Subject to a correction, your lordship, as far as my knowledge goes, there is no fresh order of retention till 19th of July 2026. This is a letter seeking approval for retention. Further, beyond this letter, I think your lordship, there may be subject to correction also, but.
It's okay, then find out.
I'll
Yes,
ask them,
Lord.
I'll ask them again. I'll ask.
The learned senior government approval just submit that
Yeah.
and affidavit has been filed by the state today, which is not on the court. So we submitted that, I said affidavit, respond number 2 has brought on record, the action taken report in compliance of order 26. Let the said affidavit be packed with record. Next para. The learned senior government advocate has submitted that in the meantime, the status report of the in respect of the functioning of the tribunals have been received, which has been looked into by the appropriate authorities for making improvement in the infrastructure. The said issue is referred for the next date. Next para. The learned American story has committed that he is in of information from various foreigners tribunals that the central government has not formally passed any order for retention of the members of the foreigners tribunals function in the state. And accordingly, we submitted that the salary of the learned members of the office staff has been kept on hold. Next, this regard, the learned senior government advocate has submitted that the appropriate authorities have written to the Government of India, this department.
But that letter has been given to the assistant. They have written to the Home Affairs Department, Ministry of Home Affairs.
Minister of Home Affairs.
And according to their information, the Home Affairs have sent the matter to the Finance Ministry. It is with the Finance Ministry at present.
And according to the information received, the matter has been sent to the Finance Ministry, Government of India. And thereafter, appropriate orders will be passed by the central government. And only thereafter, the state would be in a position to release the salary of the members of the foreigners tribunals and the office staff. Next up. the lack of retention orders for the we cannot appreciate it as it would affect the commercial functioning of the forest value. Therefore, cover the best interest of the state that the competent authority will take appropriate steps for ensuring that the members in the office staff of the foreigners tribunal receive their salary and other payment within due date, including the areas which have accumulated. If there's no retention, then this orders, what you call the cost of petrol and all oil lubricants, this is also not being paid then. How will the members travel?
In fact, Manoj, as regards the fuel, we have stated in paragraph 15 of our affidavit, Manoj. Upon receipt of the regular budget in the financial year, necessary allocation should be, they will give, Manoj.
So that is for the that particular
Yes.
corridor.
Yes, Manoj, in the,
What happens to the entire state? If you don't have retention, then obviously you can't spend for petrol also. Then
even the other
how will they function?
same problem will, same problem will arise with all, Manoj.
Then we'll have to issue a direction to all the tribunals to send their what you call due statements about the unpaid salary and other expenditures. So therefore, the court is compelled to take note of the anomalous situation where the members and the office staff are not getting their salary. Perhaps there would be other pending bills. So therefore, court is inclined to issue a direction to all the foreigners tribunals to provide the to the learned magistrate the details of unpaid salary and other bills. So giving a breakup for the same so that it is easier for the court to take note of the nature of pending bill in the period for which such bills have been raised. Next paragraph. In this regard, the registrar with the administration shall transmit a copy of this order to all the foreigners tribunals to get oversight. This will be sent by you or by the this transmission of the orders will be sent by you to the tribunal or through the will send it to the amicus curiae. Lordship, you can make it that. Okay. In the meantime, on the next date, the state government will inform the court about the status of payment of outstanding bills to the government members and the office staff and other pending bills. The learned, Michael Square submitted that he's in receipt of another communication from a book publisher to the Common Political within bracket B department for supply of law journal for the additional 7 foreigners tribunal and for supplement volumes. Purpose of the thing that the Common Political B department can take up all of that communication. Yep. In view of the statement that the statement made by the senior government advocate that the status report of the nature of infrastructure of the various partners are being looked into. The Common Political within bracket B department shall inform the court on the Wednesday of this week regarding the status of infrastructure and the steps taken for rectifying the for improvement of the infrastructure. Next list of then.
Well, the first of August, 21st of August. That is on the same day, Latika speaks the earlier case on 25th of August. Latika speaks it date on 25th of August now. Gotcha. There are few more issues we'd like to place on the next day, Lord.
What is there, is there this colors, you can make it about yet. There are other 2 matters I'm seen in the list. We don't have time to take up those matters. Item 2 and 3. Has to be registered someday. The other item 2 and 3.
We'll provide this, we'll actually allow, we can provide the whole lot a lot.
No, you have to tell us because we won't have time to read all this.
There is a letter, Your Lordship, regarding deployment of security personnel from the FT number 5 Kamrup, Your Lordship. I'm extremely sorry I'm troubling Your Lordship now. As usual. Security personnel.
Mr. Das,
Yes, Your Lordship.
you see, this security and all the other things, These are, I think, routine matters between the tribunals and the government. We are not taking over the management of the tribunals.
As a lot of things.
If there is not there, they have to move it and then appropriately bring it to the notice of the court.
Yes, a lot of things. There are two more.
Otherwise, what happens is that today is constituted, tomorrow it will be a.
Then another issue will come up, a lot. Correct, a lot.
What you call, office stationery equipment is not there.
There is another letter also from the member Nalbari, FFT number 1, Nalbari, regarding vacating the office of the Foreigners Tribunal number 1, Nalbari a lot. They have been asked to vacate the premises a lot. Nalbari.
No, who is the, see,
Sir, copy of that.
please tell me, please tell me.
Yes, a lot.
If, who is the tenant in this case?
Yes, sir, the government side also.
Hmm?
हाँ यहाँ पे number 1. There is another lordship from member Foreigners Tribunal Chirang regarding relocation.
No, you see, there are certain things where it is very difficult to pass a judicial order.
I understand.
In this case,
Yes, a lot.
the Nalbari Zilla Parishad says that the house is in a dilapidated condition.
They asked to vacate the premises for
And
relocation.
the same has to be demolished.
Yes, a lot. For them.
Now, it's essentially a communication between the landlord and the tenant.
Correct, a lot. Totally correct, a lot.
And in this case, in the Foreigners Tribunals, who are the landlord? And who are the tenant? Is it the Home Department or the tribunals?
Must be the Home Department.
So we don't know. It is that priority. You see, if I am the presiding officer, I am just thinking aloud. I'm not, I don't say that I'll do it, but I'm just thinking aloud. If I am the presiding officer, I get a notice from the Nalbari Zilla Parishad to vacate it. I am a law-abiding citizen, I vacate. Will I get my salary? You can't deny that salary. If I am ready for working, you just don't have the premises. I'm a law-abiding citizen. The authority of Nalbari Zilla Parishad asked me to vacate. Why should I dishonor the government?
As per
Will of the
the,
government.
as per the inspection report which I have, which is placed before lordship today, they said that the building ownership is a government building, officially hired building. It is a government building.
That's why you see, it's a government building. It belongs to Nalbari
The
Zilla
Zilla
Parishad.
Parishad, the Zilla Parishad,
Now Zilla Parishad asks the tribunal to vacate.
lordship.
Now this tribunal is a law-abiding citizen,
Hmm.
presiding officer. He vacates tomorrow.
Hmm. Salary is a issue.
And it can't be stopped.
No,
No,
it can't.
And what will stop is the proceeding only.
Ultimately,
And who will take the records? Home Department.
for the deputy commissioners, one of these things are being maintained. The Home Department is maintaining those things for the deputy commissioner.
Then
So the deputy commissioner has given the accommodation.
you have to give us standing instructions to the deputy district commissioners.
Lots of. From the Home Department, possibly the DC has also communicated something to the Home Department.
It has gone to home. To say that the other amicus curiae has what is submitted. There are other petty issues which has cropped up since the last date of this thing. Some of the instances stated are that deployment of security personnel on the shifting of the furnace terminals. Comma B. Receipt of notice from the landlord for vacating of the furnace tribunals. The opening of the board, comma, the same, the issues raised are basically day-to-day management affairs. Comma, the court is inclined to direct the secretary to the government of Assam, comma, Home and Political Department. To take note of communications received by the said authority regarding notice by the landlord of for vacating the furnace tribunals. Similarly, comma, the superintendent of police of the various districts who are in receipt of request for deployment of security personnel at the furnace tribunal shall also take a call on such communications received. Next, the learned senior government advocate shall transmit and download the copy of this order to the Home and Political Department, which would in turn apprise the district commissioners of all the districts and the superintendent of police of each district to take timely call on the request made for by the landlord for vacating the furnace tribunals and for deployment of security personnel. Full stop. Next part, list on 25. Sorry, we are listing it on 28/7. So this too, we have passed a general order that the Home and Political B Department, you will communicate with them. And they will communicate it to the deputy commissioners and the superintendent of police for taking a call on issues of security and vacating of premises.
Lordship has fixed on 28th of August. 28th of August. 28th August.
No, sorry, 25th of August.
25th of August. 25th of August.
25th.
Gotcha. Same thing again.